is an urgency because the T board has issued a predetermined show cause notice, and that show cause notice is predetermined to cancel our license, Your Lordship. So
You have issued a show cause notice.
the T board, Your Lordship. So the notice itself is arbitrary and it is premeditated, Your Lordship. They are just doing a formality with that notice. So there's an urgency.
Show cause notice, you reply.
We have done the same, Your Lordship. We have done the same, but they have the show cause notice is predetermined, Your Lordship. They have already premeditated what action they'll take. They have predetermined our guilt only, Your Lordship. So that is where
You want it when?
on the 4th, Your Lordship. Much obliged.
May I please, Your Lord? Hello. See the electricity connection which we have preferred. The petitioner is a private limited company and is in occupation since 2015. And my lord, I have annexed the certificate of incorporation where the address is also reflected in the tenanted premise at page 16, my lord. Page 16. Down below, my lord, the page. Ajita's Ventures Private Limited, Silver Square Mall, above West Side, Christian Basti. The Silver Square Mall is the tenanted premise, my lord. And 17 is the trade license, my lord. Again, on the same premises, my lord. Now, what has happened, my lord? There is a subsisting tenancy agreement which I have annexed at page 80, and the agreement is valid till 2027. My lord, may kindly have page 20. My lord. Page 21, first para. The lease shall commence from 1/9/2024 and shall continue for a period of 3 years until 31/8/2027. And my lord, subsequently there has been a dispute, and the respondent number 5, 6, 7, and 8 has filed a civil suit which is pending adjudication before the district court, my lord. And the order and both the suits are kept in abeyance. I have annexed the orders, my lord, at page 32. At page 32, my lord. The name of Archana Brahma Deodiyari, my lord, is the respondent number 6 here. Page 32, my lord, has got page 32. Well, both the suits at page 32 and 33 are kept in abeyance, and this is pending, my lord. Well, in the meantime, my lord, what has happened? There has been incident of disconnection thrice, my lord, and I have lodged police complaints to that effect. And the last complaint which was lodged was on 26/4/2026. I've annexed that to page 26, 29, my lord. 29. Page 29, my lord. Relevant at page 30, my lord. Third last paragraph, page 30. On 23/4, one Ramijur Rahman, a representative of Srimati Archana Brahma Deoriyari, visited our office premises. Once again demanded 10 lakhs. He further threatened that if said amount is not paid by 24/4, the electricity connection would again be disconnected. On 24/4, Archana Brahma Deoriyari, through her agent Punin, once again illegally disconnected the electricity in the name of the landlord, my lord. But pursuant to which, my lord, I have already applied for electricity connection, separate connection, my lord, which I have annexed, my lord, the application. I have also annexed the application at page 38. My lord, the landlord, my lord. For eviction. For one of the prayer is for eviction, and another suit is for recovery of money. And there is a dispute. You're not paying the rent. No, my lord, the dispute was with the previous term. My lord, this tenancy agreement which I have just placed, my lord. Prior to that, my lord, there was no dues. After she had entered into that agreement, all of a sudden there was a demand of 13 lakhs. And that was put to, and a suit was filed, and we have filed a 711 application before the trial court. Order 7 Rule 11 application, which is, my lord, which is why, my lord, the court being satisfied, because this was a commercial dispute, my lord, under the Commercial Courts Act, my lord. And the court did not have jurisdiction, so therefore my 711 application was entertained and the suit has been kept for any abeyance. But be that as it may, there is a tenant-landlord tenant dispute. That is a separate issue, my lord. Now, my lord, I am a private limited company discharging and carrying out business from the tenanted premises since 2015. For 11 years, I have been the tenant, my lord, and there is a valid tenancy agreement which is also subsisting and valid till 2027. I have applied.
Where is the valid tenancy agreement?
Yes, my lord, at page 21, I have just traced, my lord. It starts at page 18, my lord. Page 18.
What is the period of that agreement?
Yes, my lord, at page 20, at page 21, my lord, may kindly see first para, page 21.
What is the period of the agreement?
My lord, 1/9/2024 and shall continue for a period of 3 years till 31/8/2027. Well, no notice under for eviction, my lord, has been received by my client. So far as the landlord is concerned, a statutory notice has not been filed, and the suit was filed under the.
But this agreement is, how can this court look into this agreement?
My lord, I am saying, my lord,
Then
so far as
it's
the
the-
electricity connection is concerned, my lord, I am out of
Unreached the
electricity.
technical.
I'm out of electricity, my
But
lord.
this is, you are unreached the technical.
My lord, I'm in any event, my lord, the possession which I have today by virtue of this agreement, and that is a
No,
civil
you
suit is
cannot
also
have a
pending.
possession on the basis of this agreement. This agreement is court to shut its eye. Because this cannot be taken into consideration.
My
The
lord, so,
agreement was only valid for, cannot be valid for more than 1 year.
my lord,
2024.
my lord. Well,
But we are in.
but even a trespasser, my lord, even a trespasser has, my lord, right to obtain electricity connection, my lord. Be that as it may, my lord.
Really?
So far as,
Person has the right.
my lord, there are judgments to that effect, my lord. Three judgments, my lord,
One judgment will.
the other one is, my lord, so far as the tenancy value, tenancy agreement is concerned. Section 43. It be a super bill.
Paragraph 9 is different. Paragraph 9 is different. This is because they are asking for no objection. But
Yes.
where does it say that you are a trespasser can be?
But not that, my lord, not that judgment.
Which judgment trespasser can be?
Well, this is.
We come to paragraph 11 of the judgment of Justice Court. You have just relied upon the judgment, no? So the automatic. 2026 SCT line Gauhati 1822. Yeah. You have given me 2 copies of it, 3 copies of it.
That's a, that was handed over by mistake, my lord. I will not return to that rule again. My lord, so far as my possession is concerned, my lord, kindly appreciate, my lord. Page 16, my lord. I am a private limited company carrying out my business since 2015, my lord. This is the certificate of incorporation which I have annexed at page 60. At page 16, my lord, kindly see the date.
So,
2015, my lord. Since 2015, I am under occupation, my lord. And the
but you
trade
don't have
license
an
is also,
agreement
my-
today.
so far as my possession is
I'm
concerned.
not asking for a no objection. They cannot insist for a no objection as per belief that. But my question is where is your agreement that you are in possession?
My lord.
If we don't look into that particular person.
But there are some judgments which.
Which one?
Don't
Which
have those
one?
judgments. One I have given, Kamru, my lord. Kamru.
Huh?
This section 43, my lord, there is a duty to supply on request. I have handed over the judgment, my lord, 2011-12 SCC 314.
What does it say?
My lord, kindly have para 7, my lord. Referring to section 43 of the Electricity Act, my lord.
So they, the requirement of providing the electricity, provided you meet the requirements.
And so far as
Where have you
possession
filed-
is concerned, my
Have
lord.
you submitted a document, an application in terms with clause 4.5.2 before the authorities?
My lord, I have filed an application with
No,
all
no,
the.
this type of application would not do. You have to file an application in terms with clause 4.5.2.
Temporary connection.
Temporary connection.
But the problem is for temporary connection, I am obtaining that one. It amounts to around 5,000 per day. 5,000 rupees per day because they charge around.
So
per unit.
then the, you want this court to apply to you, in very well apply to, pilots to apply section 6. You are a tenant.
Well,
So not to evict you without due process, one. Second pair, file an I in terms of section 6 of the Rent Control Act to get the connection. The court will be made. And why we put
that will be a lengthy procedure.
no, that is also urgent.
And
So cannot come here like this.
So far as possession is concerned, my lord, even a trespasser has. Right. I
Do with that trespasser, because tomorrow
Have-
trespasser, you want a permanent connection, Mr. Counsel. For temporary connection is okay. I can pass an order. They will provide it because they have the rules. I cannot say that the rule is bad. So therefore, if you want a connection, it has to be a temporary connection. That is the connection. Otherwise, there is a provision under section 6 of the Assam Rent Control Act.
Yes.
Urban areas. So there, when you file that application, there will be obviously a direction by the civil court to maintain the connection. It is the bounden duty of the authority, by the landlord, to give you the connection.
So far as connection is concerned, my lord.
I can give you only a temporary connection. You don't want that. Because Mr. Pathak, you can only give a temporary
My
connection,
lord.
not a
If
permanent.
they apply in terms of 4.5.2, we can give them a temporary. Well, so far as the permanent connection is concerned, possession is not disputed, my lord, as a tenant.
Very well. So therefore, you are necessary to file a suit. Why you are coming before this? I can give you a temporary connection, and you don't want a temporary connection.
My lord, because in similar cases, similar release.
Which case the court has allowed you that you can get a permanent connection soon?
Yes, decided. Three cases.
Huh?
For late and,
Which one?
cited by my lord.
All the three cases are different.
My lord. Samsul Haq, my lord.
What did I do with the Samsul Haq?
there was a
This is only a no objection. This I applied as per the no objection.
yes,
But
madam.
here you want a connection. I gave you, here also Samsul have got a temporary connection. Isn't it, Mr. Pathak? Also, he has got a permanent, yeah. Day before yesterday also I passed one order.
My only limited prayer is, my lord, with regard to no objection certificate. The connection may be given, so far as the no objection certificate is concerned, my lord.
As per 4.5.2. Because later on I don't want the contempt to be filed against the APDCL approach. What do you say, Mr. Pathak? Because he will say, let us say to the, that providing the connection without insisting on the objection.
That will suffice, my lord, I think.
But you have not filed the application.
What a permanent connection, I think.
You cannot get an application. You have to file a proper application and they are not giving you. They say that you have mentioned your list of dates. Go and get an order from the court.
But in this matter, the real fact was the original landlord, he wanted his service connection to be disconnected. That is why your lordship had directed if the tenant wants a fresh connection with new, then he can.
But I didn't say
No.
anything, but you must have given a temporary connection, yes.
Because the original owner wanted his main connection to be disconnected. That is why the tenant wanted the fresh connection in some law. This is reflected in paragraph number 5. Last few sentences.
Okay, what is this? He has made certain allegations of welding and all.
Yes,
What is this? How can a meter be tempered?
yes, that would amount.
That's a serious allegation which he is making. We will look into it. Because if you just open the meter also, then you hold it for tempering and all. But here he is making the very serious allegation in the first information report. The landlady committed an act of mischief by creating a short circuit into the MCB located on the ground floor of the building. Due to such service, we suffered substantial loss as revenue. The act of sudden disconnection of ear, this is one of the one.
Advise the concerned subdivision to perhaps conduct an inspection. I'll advise the concerned subdivision to conduct an inspection.
Conduct an investigation into this. Let's issue a notice. And if he applies for the connection, as per you, you give it temple. I'm not saying temple, but it is your prerogative. But you give it, you do it at your own risk and cost. So notice it is returnable on 12th of June 2026. Mr. KP Pathak appears on behalf of the Learned Standing Council APDC. Appears on behalf of respondent number 1 also no. 2, 3 and 4. 1, Mr. Dhar, you appear for 1. You are a government council, no? Okay, Mr. R. Dhar appears for the respondent. The learned additional senior government appears for the respondent number 1. The KP Pathak appears for the respondent number 2, 3 and 4. Extra copies of the petition be served upon the learned councils during the course of the day. As regards the respondent number 4 to 8, 5 to 8, the petitioner is directed to take steps by speed post by tomorrow. In addition to that, the petitioner is also directed to take steps by way of dusty routed to the registry of the spot and file an affidavit of service on or before the next date. The petitioner further directed in that while effecting service by way of trustee upon the respondent number 528. The petitioner should ensure that the service is meted out on or before 15th of May 2026. The case of the petitioner hearing is that the petitioner entered into an agreement of lease with the private respondents herein in respect to the middle portion of the third floor of the commercial building known as Silver Square, situated at Christian Basti, GS Road, Gauhati 781005. The said tenancy agreement is valid up to 31/8/2027. It is the further case of the petitioner that on account of the interference caused by the private respondent, the electricity connection to the petitioner's tenanted premises have been disconnected. The petitioner have also sought for a connection by submitting an application before the respondent number 4. However, the said connection have not been provided. It may not be out of place to mention that between the parties, between the petitioner and the private respondent, there are certain disputes which are pending before the Court of Civil Jurisdiction. This court duly takes note of the judgment of the Supreme Court in the case of Dilip Dev versus so-and-so reported in so-and-so, wherein the Supreme Court observed that supply of electricity is an essential service. And under such circumstances, on account of the disputes between the parties, the distributor should not deny this essential service. The Supreme Court further observed that the distributor can grant the connection, can provide a connection without insisting upon the no objection from the landlords. Mr. K.P. Pathak, the learned counsel standing counsel appearing on behalf of the respondent numbers 2 to 4, submitted that the connection, if to be granted to the petitioner, the same has to be in terms with the AERC regulations 2019-17, and the petitioner would be required to file applications in that regard, and not by submitting a representation before the respondent number 4. The learned standing counsel further submitted that if the petitioner seeks for a separate connection, the petitioner has also to fulfill the conditions mentioned in the said regulations. Taking into account that the supply of electricity to be an essential service, this court in the interim provides that if the petitioner submits an application in terms with the regulations of 2017 to the concerned respondent or authorities of the APDCL, a separate connection be given without insisting upon the no objection from the landlords, subject to fulfilling the terms and conditions of the regulations listed accordingly. What is this?
So impediment of the first wife, of the deceased husband of the writ petitioner. Courtship may perhaps recall order dated 19/2/26. After going through the
You want to make number 7
number 7 apart because Malak, she is the first wife.
I remember
Yeah.
without 7, I could not have disposed. I wanted to dispose of the petition, but 7 also has a right.
Yes.
And you were insisting on that order passed by another coordinate bench and saying that because of that, you should be getting it because of the fact that there was a case filed during when your husband was alive.
Yes.
Yeah, because of that, wife had no right.
Gotcha.
When the pension dues, there was a family court direction that not to release the pension.
Yes.
That's the
Exactly.
fact.
Yes.
Okay. They make it.
More the merrier, my lord.
Eh?
More the merrier. Now these are all factual thing, my lord. Dispute. That's the
There's an application filed by the petitioner as applicant to implead the opposite party number 7, who was the first wife of the husband of the applicant, as a party to the accompanying petition on the ground that the presence of the opposite party number 7 would be essential for effective adjudication of the accompanying of the dispute. Mr. A. Ganguly had further referred to the order passed by this court on 19/2/2026 and submits that in view of the said order, the present proceedings cannot, the accompanying proceedings cannot proceed without the opposite party number 7 being made a party, being arrayed as a party to the accompanying writ petition. Was taking into account the order dated 19/2/2026, as well as the dispute involved in the instant proceedings, it is the opinion of this court that the presence of the opposite party number 7 to the accompanying dispute to the dispute in hand is necessary for an effective adjudication. Accordingly, the opposite party number 7 is arrayed as the respondent number 7 to the accompanying writ petition. Pusta. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry shall, on the basis of the present order, as well as the memo of parties so filed, make necessary correction in the cause title of the accompanying writ proceedings, as well as update the same in the CIS. I stands allowed. Now, when to issue notice upon the respondent number 7, returnable by 15th of June 2026. Petitioner grant shall take steps by way of speed post within 3 days. In addition to that, the petitioner is also given the liberty to effect service upon the respondent number 7 by Dusty routed to the registry of this court and file an affidavit of service on or before the next date. In the circumstance, the petitioner takes steps by way of Dusty upon the respondent number 7. The petitioner should ensure that the service is meted out upon the respondent number 7 on or before 18th of May 2026. List according.
Please, your lordship. Lordship, I'm sorry for an unusual prayer. Yesterday only me and my sister have filed wakalatnama, lordship.
Oh. The counsel appearing, Miss So-and-so, who appears on behalf of the respondent, on behalf of the petitioner, submits that they have been, that the petition, that she has been engaged only yesterday. So she therefore submits that some more time may be granted to the petitioner. Accordingly, the matter stands adjourned. Interim order is there. What is this interim order? Whole matter PK Goswami who submitted the letter their demand notice for revised renewal. You are not paying the regular dues.
My difficulty is on, it's a voluminous matter, so I could not go through.
Let us go through the matter together now.
That's it. My difficulty is it's a voluminous and all matter. Then I'm not able to assist my senior also today, Lordship, that's it.
Okay, list this matter on 7th of May 2026. Interim order passed earlier, 6th of May 2026. Interim order passed earlier shall continue till the next date. It is observed that on the next date, this court shall hear as to whether there is a requirement for further continuation of the interim order.
Lordship, I'm appearing on behalf of Mr.
Your name will put it in the golden language. Yes, Mr. Burua.
This is the,
Oh, that one.
yes, ma'am. Filed your affidavit.
What is the matter about?
Matter matter is that the petitioner is the first wife of the deceased employee. And the employee died in 2020. She was married in 1970 itself, This is a long time back, my lord.
What is your year? Let us see your additional affidavit.
Additional affidavit contains three particular annexures, my lord, will refer to. Annexure R1, page 33.
Rekha Borgohain.
This is my
Rekha Sri
daughter.
Borgohain Borgohain. Who is she?
This is my daughter and her father's name, the deceased employee's name is
How
reflected.
do you know that she, your daughter?
That is reflected in next of kin certificate. Same name. It is there in the writ petition.
What is the applicable age of year? You are
Page 15.
Nilima Gogoi. Name of the retiring servant, Nilima Gogoi. Husband's name where?
Husband's
The
name
event
is
of death of the Imam following which may be paid to Sri Professor Gogoi, husband of the petitioner from the date following the date of her death. Oh, this is your husband.
This is my husband. In my pension book, my husband's name is reflected. In his, my name is not reflected.
Not reflected.
His second wife's name.
Then what is this? This is the year death of Professor Gogoi. Now, what is your case? What has happened now?
My lord, my husband died in 2020.
Ah.
And because his second wife's name was in the pension book, she got pension for a few months, family pension.
She died.
He died next year immediately.
Next?
In the next year itself, 2021 itself. So before I could challenge that fact. My lord, the fact is, it means I approached the representation that I was the first wife. Therefore, even though I could not contest it at that point in time, I saw the correction in the pension book and
There's no divorce.
there's no divorce. There's no divorce.
So the second wife was illegal marriage
Second, illegal.
and they gave it.
And they have not, they said that their records do not reflect my name, therefore they were corrected.
And they have also not filed affidavit.
Finally, we are filing it to them.
Why?
I have issued to them.
The matter has been pending for 2024. Huh?
Very,
Okay, let the Registrar General out here pay the interest. Whatever you are getting. We put that undertaking. What do you say, Mr. Borwa? Because they have delayed for 2 years in filing this up.
my lord,
How can we judges at Gauhati High Court say that the government should file the affidavit when the Gauhati High Court on the administrative side, they don't file the affidavit?
my
Tell
lord,
us,
only,
give us a more enlightening view, Mr. Busho.
my lord, only in February, the registry was added. How, my lord? The government advocate received the notice on behalf of all the respondents.
So you want to put the blame on whom? Mr. J.K. Goswami.
No, in 2020.
You are a person. Huh? for which the petitioner is not making it? You are appearing for whom? Pension. Why did you accept the notice on behalf of the district and session judge? But anyways, what is the government, Gauhati High Court has to say anything out there? Pension is between you, you are to pay. Why haven't you paid it? Now with this particular document, which shows that they were married at one point of time, why haven't you filed your affidavit after accepting notice in the year 2024? What? They're responsible. Then we are going to give it. We are giving it. You have no role. Then you give it. You give it.
The marriage was solemnized in 1970. Till the date of the deceased employee, nothing has been submitted that that the read petitioner was his wife. We have no document, nothing, no application, nothing has been submitted. For the first time in 2022, it was filed. And then we have gone through the record. That nothing reflects.
Now,
We cannot ascertain whether
Mr. You have got the next of kin certificate.
I have the next of kin certificate.
Where the Nilima Gogo is there.
Yes, my lord.
So you see, my question is, why don't you do on the basis of this next of kin certificate?
my lord, kindly produce para 8, man.
Of
Read petition at page 8.
Let it say.
It said that there was nothing on their record to indicate that
Here
the
the
petitioner-
issue had taken the issue of the office of her husband's employed, but the said respondent was also hopeless, possibly helpless, as there was nothing on record to indicate that the petitioner was the spouse and the nominee of the deceased wife. As the intervening couple of years were disrupted by the pandemic, the petitioner could not take effective step for establishing her green pursuance. That and the fact is there. The fact must have been. This particular person must have married the petitioner out of their wedlock. These people were born. After this, the husband became more fond of another lady, got married to her, and thereupon the petitioner must have said that as you have, I also earned, so I don't want anything. Now, at the end of the day, when she sees that, okay, that second lady had died, why not? I tried to get some money because there was no divorce. Legally, morally, the petitioner may not be right, but legally she is right.
Now, my lord, when the read petitioner filed this annexure R2 at page 35 of his
No, no, my question is, do you have any scope to see who is the legal heir? When there is a legal heir certificate being given, when a legal heir next of kin certificate has been given to you, you have to inquire with the concerned deputy commissioner as to the veracity of this document and thereupon to proceed. This is the law. And for my satisfaction, I asked him, so he filed the affidavit. In the affidavit, which is the pension payment order of the petitioner, the husband's name has been shown. One. Number two, it has also been shown, you inquire, have an inquiry and keep it up and we follow up these people and then we do whatever you feel like. Yes, sir. But do something. It is after all pension. You are already 68 years.
And 70.
70. How long are you going to stop him not to do?
yes, sir.
When? How long? You are, because once you say, okay, Mr. Chakraborty has given an undertaking, we are putting it, he will immediately process it. No. You have not filed affidavit. So therefore we say, the moment we say, okay, we will give it. So, and J.K. Goswami said that we have no.
How to explain?
Heard Mr. N. Gover, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent 1 and 2. Mr. Gautam Mishra, who is the assisting counsel? The senior counsel assisted by so-and-so appears on behalf of the respondent number 3. Mr. B. Chakraborty appears on behalf of the respondent number 4. The petitioner, who at present is 75 years old, 75 years old, had to approach this court seeking the family pension, which the petitioner claims to be entitled, being the wife of late Rupeswar Borgohain. Borgohain? Borgohain. Borgohain. In that regard, the petitioner, it is the case of the petitioner that the petitioner have also been issued the next of kin certificate by the appropriate authority, by whom? By the circle officer, by the office of the Deputy Commissioner, Lakhimpur District. And the said next of kin certificate along with the death certificate and the next of kin certificate was submitted before the respondent number 3. However, the pension proposal having not been sent by the respondent number 3, on the ground that in the pension papers of late Rupeswar Borgohain, the name of one Anu Borgohain, who has also expired, was mentioned as the spouse. The respondent number 3 had not sent the proposal. Instead, a petition was listed before this court on 26/2/2026, when this court inquired with the learned counsel appearing on behalf of the petitioner as to what materials are available with the petitioner to show that there was a marriage between the petitioner as well with late Rupeswar Borgohain. In that regard, an additional affidavit has been was filed by the petitioner on 2nd of April 2026, wherein the petitioner not only enclosed her PAN card, daughter's PAN card, wherein PAN card, but also the pension payment order of the petitioner, wherein the photograph of the petitioner along with late Rupeswar Borgohain is duly shown in the said pension payment order. It is also mentioned in the said pension payment order that late Rupeswar Borgohain was a beneficiary in respect to, in the circumstance the petitioner expired. In addition to that, the petitioner have also enclosed a certificate issued by the Gaon Pradhan, wherein the petitioner has been mentioned to be the wife of late Rupeswar Borgohain. It is the opinion of this court that pending next date, the respondent number 3 is required to make such necessary inquiries and come to and arrive at a finding as to whether the petitioner is the wife of late Rupeswar Borgohain on the basis of the materials and then submit an affidavit before this court. List this matter again on 18th of June 2026. In the meantime, the respondent number 3 is directed to carry out the necessary verifications and thereupon submit an affidavit before this court. I think so.
Yes, it's always said.
The petitioner, the respondent number 3 shall call the petitioner and the petitioner shall submit all these materials which have been enclosed with the petition. And more particularly the original of the PPO of the petitioner before the respondent number 3 during the course of such inquiry.
Okay.
Any development?
Yes, Lordship. Lordship, yes, Lordship. On 26/03/2026, the Law Department of Law received the final draft, Lordship. That was sent on 23/04/2026 to the Legislative Department, Lordship. And after vetting, Lordship, it will place to the Cabinet, Lordship, new Cabinet, and thereafter it will be.
Let's wait after court.
Yes, Lordship.
It has been submitted by Mr. J.K. Goswami, the learned additional senior government advocate, that pursuant to the final draft final conferred draft sent from the High Court on the administrative side, the same was placed before the Legislative Department of the Government of Assam. The learned counsel submitted that the new government is likely to be formed after the results are pronounced on 4th of May 2026. He therefore submits that some more time may be granted. List this matter again on 18th of June 2026 for an update. What do you want?
My lord, I need some time to file affidavit. It is on betting statement.
No, they cannot be betting. Betting doesn't take 2 years. What is your case?
It's a matter pertaining to the service of the prisoner where he was reverted back to his post,
Yours?
where he was promoted, but he was reverted back to UTA after 2 years without showing any cause.
Where? In pursuance to the selection held on a Seniority permit who was promoted to the post of so and so. He thereby reverted back to his earlier post so and so on demand. Now show me your promotion.
At page
Eight,
24, next up
24.
24.
Aripa upper division player is promoted to the post of civil register so and so in as per the usual rank carrying the identical pay while we are promoted. So you have been promoted.
Yes.
Yet where? Hubli. Then A of so and so yeah, in the pre-promotional post like so and so is hereby fixed in the promotion to the civil register.
Then kindly see my note. Page 27.
In pursuance to the selection board's meeting held on Iman, who was promoted to the Iman so and so is hereby reverted back to his earlier post. There must be some order somewhere.
Yes, sir. Your lordship's order.
What happened? Right? Otherwise, there is no reason why.
There's no. In some other cases. In some other case.
Another case, but
Yes, sir.
probably the promotion of that particular person must have been interfered. Amo. What are these two? One judgment.
4370, madam.
Supervisory assistant in the establishment of alia. Who was affected? What is this? Amini Kumar Das, that is different. Why, Mr. PP? Okay. What? Amini Kumar Das. And who was affected? Because he was promoted on the basis of somebody.
Yes, madam.
What was his name? Rizwal Ahmed being promoted.
No.
Was his promotion interfered with?
Kindly come to Tenant 9.
Of
4370 of 2020.
Para 9. SC Biswas.
Yes, madam.
The learned senior counsel appearing on behalf of submitted that admittedly respond number 6 is junior to the petitioner. But by the same impugned order, another junior officer, namely one Arif Ahmed, who is at serial number 12 of the gradation list, has been promoted, granted a promotion to the post of Imam. He submitted that if there is an interference by this court to the orders being passed, respondent number 6 would be relegated back to the supervisory assistant, whereas the junior officer would be promoted to the post of civil solicitor in the establishment of so and so. Duly peruse the materials or record the pleadings as well as so and so. This aspect of the matter will be admitted in the affidavit of my petition, therefore arises in the incentive is whether the selection should be was done, taking into account the criteria so and so. Shivaya so and so. In the backdrop of the real Supreme Court so and so. Six and
Then para 40.
but tell me one thing.
Para 40.
No, wait. It was done on 2024. Therefore, for parking of according to So there, I didn't challenge. I did not set aside Arif Ahmed.
No.
Then what?
Then as per paragraph 15.
If he challenges, it's a different thing. Response number 6 had challenged is a different thing. So
Yes.
therefore, why did you do this?
And response number 6 had one representative.
Then no.
On that basis,
We said things. This you can.
In fact, in what supporting case, I was there.
What happened? You were a party.
No. I was appeared for almost 2 years.
You were a council.
Yes.
And now therefore they have got hold of you.
Yes.
Because you saved the response, the petitioner. Yes, tell me what. No, that is for response number 6. Because kindly see paragraph 14. I categorically say that I am not going to touch them. If before parting, this court also finds it more pertinent to take note of the submission made by Mr. S.C. Vishwas, learned counsel appearing for instance to the effect that one RD farmer who was junior to the respondent has promoted to the post of civil sales tailor in the appeal. This court had duly taken note of the selection which was carried out in respect to the state so and so and from annexure 8 to the affidavit filed by respondent number 5. It reveals that the same was a separate selection which was held on so and so. The respondent is agreed by the promotion of alia to be at liberty to do so if permissible under law. I know it's set aside. No, you cannot. No, who are you? Your appointment has been challenged. Have you challenged his appointment?
Yes, yes. He was new to me. He was new to me, and I took succession. He has been promoted
So
twice.
what they did is remove you.
By removing me.
Your name was Amini Kumar Das.
Nilam Tepalkai.
Huh? In the present date, you are
He's the restaurant number 7.
Unilam Dev. And you are challenging his appointment.
Yes, sir.
On the ground that you have been removed without anything.
And
You are not fine. We stay your appointment. And not to give you salary or without match your money from. No, you have not filed. After 2 years, this has gone. This is not done. What case you have? No case. And what is happening with these people there? Man? Whatever you feel like doing, you do it. Not necessary. You file your affidavit after you can't get the official documents in 1.5 years. Then well, good that we should not be capable enough to give a defense. Division bench may help you out. No, because you could not just remove him. You could not have removed him. And thereupon, hold the selection. And he participated.
he participated.
Why did you participate? Yes. Are you not giving up your right there?
They gave me 4 months. And they gave me 4 months.
What? No, man, that Mr. Counsel, tell me. You should have stopped there. You got that order the moment you are reverted, you should have come before the stroke. You did not come. Then you participated in pursuing for the selection or they took you on to the selection.
They gave me they gave us no time. So
What?
they quickly came to that.
Hmm. And this is merit comes seniority come merit.
Seniority comes in.
My lord, what happened in this election? There, as per your lordship direction in other cases, minimum benchmark was there.
What was the minimum merit fix?
Minimum benchmark was there, he could not satisfy that.
How much was the merit, minimum merit? 40.
That I had to.
Although they are reverted me back to EPA, now I'm still in charge. They gave me work, still in charge civil session.
No, Mr. Counsel, you are not speaking. Tell me, what was the minimum mark? 70? He got 33, then he got 70. Where 70%? You know everything because you have been being brought out there. But why you are putting the minimum at 70%? There's another judgment which I passed now. Look at it. There's another judgment. Mr. Where is Mr. H.K. Das? That day I passed one judgment. We produce the records. Final. I produce the records next Thursday. 7, produce the records. You file your, both of you file your affidavits. If you want to file, don't file, we'll go as per doctrine of non-payers.
File that.
I think I'm not concerned. You don't file, don't file.
They are waiting.
The petitioner herein has approached this court challenging the illegal action, challenging the actions of the part of the respondent authorities in reverting the petitioner in we put it in a different manner, Mr. Counsel. Let us put this, your submission in a different manner. You may have a good cause. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Gautam Bashir, senior learned senior counsel, assisted by so-and-so appears on behalf of the Gauhati High Court. You are also Gauhati High Court and appearing here. How a private respondent can also be a Gauhati High Court counsel? You take it out. Next time if you appear, you take it. Now we say, Mr. P.P. Bratto appears on behalf of the Gauhati High Court. Next time you can't appear in any matter, even those infrastructure matters. You cannot appear unless the Gauhati High Court gives a power of attorney to come. Appears on behalf of the private respondent. Mr. So-and-so appears on behalf of the state government. The petitioner herein was promoted to the post of civil solicitor in the office of the Munshi Bilasipara by an order dated 3rd of March 2022, pursuant to a regular selection process. All of a sudden, on 23rd of April 2024, the petitioner was issued an order by the district and session judge Agri, whereby the petitioner and a penalty was imposed upon the petitioner by reverting the petitioner back to the post of upper division assistant, which is in gross violation, which the petitioner claims to be in gross violation to Article 311 of the Constitution, read with Rule 9 of the Assam Services Discipline and Appeal Rules 1964. The petitioner further is agreed that upon being reverted back, the petitioner, the said post was filled up by another selection process, whereby the petitioner was not selected. The learned counsel appearing on behalf of the petitioner submits that the reversion back, the penalty so imposed without issuance of a show cause notice violates the petitioner's rights under Article 14, 16, and 21 of the Constitution. And as such, even assuming for argument's sake, though not admitting that the petitioner participated in the selection procedure, the said cannot be said to be a waiver in as much as there cannot be a waiver. It is a settled principle of law that there can be no waiver of the fundamental rights. The records further reveal that no affidavit has been filed either by the Guwahati High Court or by the respondent number 6. No affidavit. Taking into account the said submission and the matter having been adequately heard, this matter on 7th of May 2000, let us not have it on 7th, we'll have it on 14th of May 2026 at the top of the list for final disposal. The Standing Council of the Guwahati High Court shall produce the records of the selection process. A final liberty is granted to the Gauhati High Court as well as the respondent number 6 to file their reply on or before 11th of May 2026. You come up with that judgment 311 and here and Article 14, 16 and 21 being fundamental rights cannot now. No case. Next time if you appear, we'll take it out. No, you can't. This is not done. This is all hobnobbing between the councils appearing on behalf of the Guwahati High Court. The same council appears sometimes for the Guwahati High Court and tomorrow appears on behalf of the private respondent. It is not done. No, you cannot. We have put it. It is on the stone. It is engraved. Next time if we appear, we have to take it. No, you cannot. It cannot be at your choice. It cannot. Next time, don't appear for the Guwahati High Court, please, before me. Unless there is a wakalatnama issued by the Registrar General appearing, not as a standing. Or there is a specific appointment on. Put it down. There has to be a specific. Yes, next matter. Yes, Mr. Chakravarti. Today your adversary is different. What is it?
Maluk, is 99 petitioner. They are in Indians of central destitute home. And they have been staying out there since 1958. Now, they were provided with structures which were from 1958 and understandably, as on date, the structures are dilapidated.
Now what you
They submitted application before the concerned authority for providing them with the benefits of Pradhan Mantri Awas Yojana.
are you not a citizen of India?
They automatically, by virtue of Citizenship Act, having come to India in 1958, they are the citizens of India as per the Assam Accord. They have come from East Pakistan, so as per Assam Accord, they are citizens.
Then why you are not getting it?
Now, the reason itself is not known because my limited period.
Okay, you don't know the reason. Mr. Doctor, what is the reason why you are not giving it?
Announcement of the President of India. That this scheme order wants for 4 years, 5 years, my that implementing as per the guidelines of the scheme, implementing agency is the state authority. They will verify the records and
Okay, so you cannot say.
yes, my
So
lord, I
it is
have
the
filed
state
my
authority who appears for the social welfare.
for getting benefit, my lord.
You are appearing. Why you are not giving it to these people? How is Somen Day? How did Somen Day come in 1958? He's 32 years old.
Well, they have subsequently, my lord, they have enhanced.
Are they citizens of India?
Yes, yes. Their families have expanded and in the course of it.
Yes, why haven't you done it? As per the government, it is, the union, it is that we provide the funds implementing authority of the state. So state, why you are not giving it to them?
Before this notice, earlier some other litigations are also there. regarding that rehabilitation part also.
You have not been able to give them the area where to stay.
Yes, because some earlier order is there. They have been earmarked with some 32 bighas of land. So some direction was there from this honorable court not to allot any land from that earmarked land, other institutional also.
So they are in a particular plot of land.
Yes,
That has been earmarked for them, no?
that has been earmarked for that central destitute home lordship, that 32 bighas of land.
Then,
Also some direction is there.
now, Mr. Chakraborty, tell me, do you want this particular land, houses to build?
We built in that area. In the capacity of weaving landless people. That provision is there in the scheme for
They
landless.
have to grant the benefit of the scheme along with them by holding them, they don't know that asking so and so. Or in the order for the process, the applications are submitted by the AR so and so. Now, what is this order?
My lord will come to page number 32, which is the first order, and the relevant part is at page 37.
That the I will submit that the utilized area of photo will not complete the. You were the petitioner earlier.
Some of the
So similarly situated person.
all inmates of the central district.
You are
Inmates of the
of the
central
central
district.
district. Home. You are effectively confined to the area of science. So, how it made clear that the utilized land measuring 32 bighas, 12 chattaks of the central should be protected as the refugee and settled in that area. But so now you say, in this 32 bigha, kindly provide the scheme, apply the scheme so that the construction which is in a dilapidated situation is improved. That's your case, that is not. Yeah. And that's where
143. 5.1. Beneficial.
we're referring to what?
5.1.
5.3.
5.1. 143. My opinion.
5.1.
5.1, relevant is 5.1.2. In the case
In
of
case of landless beneficiary state or their own expense, they provide heritable but non-transferable land paths to the family making them here. Okay, the state has to provide the land
yes, ma'am.
and then they can.
Malat, as per
And the
the
state has not provided the land. Okay, let us have the revenue and the DC upon.
as per the seventh schedule of the Constitution of India, state has the obligation to provide the rehabilitation of.
Okay, we'll do it. DC is there, well, let us have the revenue. What is that?
Regarding that, some of the other inmate of the same city home, they came up to the honorable court alleging that despite there being restraining order in the previous litigation, the
Now, another thing. This is a central destitute home. It is run under whose aegis? Under whom it's run?
Might it at the emergency or the order, which is some situation, they came to the entered into India.
Understood. My question is not that you have named it as the central destitute home. Is it run by the central government or the state government?
No. Social welfare. Social welfare.
Huh?
Social welfare.
Now, therefore, the social welfare.
Yeah.
Okay, let us forget about the Pradhan Mantri business and all. Let us have the social welfare and find out as to whether they can improve the infrastructure. That's all. Improve the infrastructure. Take it up with the central government and improve the infrastructure. This is what is required. You can keep the people. This is also a basic human rights problem. This is something like the Syria. No? Better than that. No. Social welfare, what is your stand?
So they have filed their affidavit. Social welfare has filed their affidavit.
What do they say?
In their affidavit, there is some juxtaposing statements being made by social welfare saying that the accountability of the union, and the union is saying the accountability of the state as well as the social department.
No, let us not go by the Pradhan Mantri Yojana. Let us not go by that. There is an institution which is there. It is known as the Central District Home. It belongs either to the central government or the state government, whoever it is, it belongs to you. Isn't it? To both of you, I'm asking. The Central District Home belongs to whom? It belongs to whom? Okay, we do one thing.
Now it's
Let's have this.
state.
No, the Deputy Solicitor General. Let him appear.
He appeared previously.
No, Mr. Datta, you are not.
My lord,
taking this.
my lord,
Okay, list this matter.
my lord,
No, you are not helping this one. List this matter again on 21st of May 2026. The Mr. R.K. Dev Chaudhary, the Deputy Solicitor General of India, is directed to appear on behalf of the Union of India in as much as India. Mr. A.K. Datta, the learned CGC, shall duly intimate him that his presence is sought for by this court in the present proceedings.
Order. It is 11. It is 27/11 now.
Yes, Mr. Mohammed, what is your case?
Now, my lord, after this order was passed, my lord, you also directed us to file an IA on 11/12/2025.
For giving up some.
Yes, giving up the this one number 4 and 5. But it will also recast it, then 4 and 5 will be out of the scope.
What will they say?
On 11/12.
It would be an adman only.
Yes.
What would they say?
My lord, the lordship directed us that the instruction whether they want to withdraw from the system, but if they continue, then it will be a difficult situation. But if they lordship recast it, then these 2% will be affected. Since we are representing these two,
Why should I give you the liberty?
but otherwise, the lordship will come.
If you want to withdraw, you withdraw. But why do I give you the liberty?
They are not pressing this instant.
Why do I give you the liberty? Not pressing it very well. You can very well, order 23 rule 1 say, any stage, some of the persons can withdraw. My question is, why should I give you the liberty?
Otherwise, you know, only but liberty is not given.
You have to give us a good reason why liberty. What you say, Mr. Das? Give him a liberty.
No, otherwise, their appointment will go. It's like, because the entire selection list has been settled.
Then why they are withdrawing?
Pilot is also directed on the last occasion.
I never directed. I only say, that Mr. Das wants to represent
Just
everybody,
the discussion.
taking into account that you have, some of the petitioners may not get through. And would it be right on the part of them to canvass for some and canvass not for some? Because 3 posts could have been saved, but 2 posts can't be saved. Because you see what has happened, when I passed my judgment, I interfered with the 3 appointments. These 3 persons were reverted back. When these 3 persons were reverted back, in the meantime, on 10/4/2025, there were 5 persons who have been appointed. Now, out of that, these 3 goes. Now, the next question comes in. Now, you come up and say that why there is a requirement of a fresh selection. Now, they say that it is not only the reason for which we have on behalf of the, on account of the judgment passed by this court, but also for other reasons in view of the fact that one person, some function or something, he filed a complaint and it was found that the entire selection proceedings were vitiated. And as such, they want to go for a fresh selection. That's it. So now, therefore, at that point of time, while I was dealing with the matter, I said, forget about the second ground. If it is the first ground, 3 persons could have been saved. If 3 persons can be saved, can you converse on behalf of 5? Correct. Means are you then not fighting amongst the 5 because all 5 petitions. Then now you say that 2 persons want to withdraw. Now, if these 2 persons want to withdraw, they have to give up.
Pilot, if the lordship passes an order recasting,
You see, the question is right there. See, that is why one should not normally file this type of writ petitions in there. You have filed all the writ petitions together. There, the problem arises. You may have to withdraw the entire writ petition, and with liberty. Then the thing is different. And then only 3 comes in. But if you ask for 2, he has to abandon. You see, we have to go by the speed of order 23(1). Where is the CPG? You appear before this court without a CPG. Give it to him. That's the fundamental principle. What do you say, Mr.
Correctly. Because again, there will be
He has to
difficulty.
withdraw everything.
He has to withdraw and
then
file
come
a
up
fresh.
with this. This is how you want to do it. Then you also will have the liberty. You have to file separate. Therefore, when there are competition amongst them, you cannot join together and file it.
Even if it is deleted, the stain remains, my lord, in the same proceeding.
Because you have to abandon. But you cannot reserve. You abandon, you cannot reserve.
We give me 1 week's time. I will.
Think about that. Remember what I said with the Das on the next week to reach for them.
Yes, madam. Yes, I'll apply the process.
See that, see what is the order taking doing. You can do it. You can do it. At any time after the institution of the suit, the plaintiff may, as against all or any of the defendants, abandon his suit or abandon a part of his claim. Provided where the plaintiff is a minor, an application for leave under the proviso of heir shall be accompanied by an affidavit, the next step, that is called the proviso. Where a court is satisfied that the suit must fail by reason of some formal defect or so and so it may be. Nothing in the rules shall be deemed to authorize the court to permit one of the several to abandon a suit or a part of the claim under heir or to withdraw under subgroup with any part of heir without the consent of the other plaintiff. How do you take care of these? One time. And more particularly, Mr. Mohammed, you have to, it has to be by a different counsel also. Impossible.
We have to file separate.
It has to be by a different counsel also. Because otherwise, if you are representing all, again there is the conflict.
Since we will not pay.
So you have to withdraw the entire petition, then with liberty. Then it's a different.
They can take those grounds also which emanated from my affidavit, because those facts were not there in their petition.
But these facts can be taken into account and then beyond that, otherwise, because here you cannot, which is again goes against your what you call. As a lawyer, you have certain duties. Now you are doing a duty which is in conflict with each other.
Regarding petition number 1, we can find what we petition.
So therefore, you need to withdraw the entire thing, come up with a fresh one, with a new. Yes. This is how you have to do. And then say that, okay, you come up with the, that is why I'm saying. Normally, you see, whenever some persons file all the persons together, you have a, always you are at the risk. If one abandons the claim, any abandon the claim, normally the courts allow. But I belong from a different area whereby I go by the citizen. You see, there are very principles. Now, if you abandon some, and you, therefore it says, one side says, you have to take the consent.
The counsel.
Now, can he say that, can the same lawyer say that he has given the consent to me? Because you are paying for him also. So there will be a conflict. Next week, ask Mr. Peter's to appear and we will then test whether.
What can we do one thing, regarding this instant petition? We like this, if this IA is allowed, then here the 5 and 6 goes, 4 and 5 go.
And for 4 and 5, can we file a fresh petition and tag it along with this one? So one order can be passed here and.
No, Mr. Counsel, how can you withdraw? Why should I give you the liberty here? You're abandoning. Once you abandon, why should I allow you? Unless you give me very good reason that you have to have it. In a repetition, why should I? You have to show that there is a formal defect. Where there are more reasons to that. It's not so easy. If you see in my court, getting a liberty to withdraw is a very big thing. Not such an easy job. Until I hold this matter up here for the Gauhati High Court, it's this problem will have you. You may do one thing, ask one, request the Chief Justice on the administrative side that this court is not so good for Gauhati High Court matters. Then you make it. Next week. Mr. K. Mohammed, the learned counsel, sir, hearing on behalf of the petitioner submits that he may be granted 1 week's time to take appropriate instructions on the matter. It's the matter of 14th May, 14th of May. Can it be on 12? Why? Why? I do. What is this?
Promotion from the junior assistant to senior assistant. District and secondary office. Knowledge. I was higher in the jurisdiction list. However, the phone number has been promoted without considering my case. My order dated 14/8.
The gradation it has to be done on the basis of seniority come merit, not seniority. Seniority come merit.
Seniority company.
Now what do they say?
Yes,
Because
Lordship, though the resolution has not been annexed, it was placed before your Lordship on 14/8. Lordship has perused the resolution and at para 6, Lordship has
That's it.
order dated 14/8.
14 yes. Yeah.
Para 6.
I've taken note of the particular item number 2 and from a page it reveals the decision which has been taken is on the basis of merit and not on the basis of seniority criterion for promotion to the post of the man. Now you have the resolution.
Yes, ma'am.
The petitioner is admittedly senior to you. You are appearing for? What post is this? Bench clerk. What is the post?
Computer type.
Huh? What computer types? Promotion to the post of senior administrative.
Senior administrative.
SAA from junior administrative assistant from Ja to Sa. Which is the resolution?
Plus the in method.
Huh?
Plus the.
16.5.
Next one.
On one clear within post of junior year, and this is for filling up of senior, then the two. But we use the final gradation list of the one. Where is the resolution?
Yes.
How is it possible? Have you been?
A lot before submitting on the fact that with the seniority come merit and the minimum criteria of merit should be present in this matter. My lord, I would also like to bring my lord's attention to the notification. The notification of 2020, that is annexure C of part of the writ petition. This notification combines all the LDA, computer typist and copyist together and seeks a competitive gradation list to prepare, in which I fall one rank below the petitioner. Followed in the year 2018, I was at rank 26 and the petitioner was at 56. This notifications came in the year 2020, and this notifications were put to challenge before this Honorable High Court. The Honorable High Court was pleased to stay and put a status quo on this matter. I have those, and the matter is still under subjudication. But my query here is that if there is status quo order and these notifications are put to are put to quite for a moment here, and the matter is still sub judice, but how will another computed gradation list with this same notification be prepared, where I be placed below her?
So then it won't be, if you go below that, what together the notification. If the disposal of that other. But the fact that this has been done wrongly, and
But that is another limb of my submissions.
the other way is, why should you be there? The fact that you are junior, you claim that you are senior, on what basis? Is there any notification by which,
In the earlier gradation list.
my question is, in the earlier gradation list, were you senior?
Yes,
Where?
2008. No, I have received it. There's additional left over to the effect.
Which one page?
No, but those are not annexed. I have those
No,
forms.
no, no, don't come up with like this.
But then granted, I took that additional.
You have filed a affidavit in reply also.
I did have five.
Sorry,
I have
you
put
can't
those.
allow this type of thing. There's a stay also, na?
Yes, ma'am.
So nobody is there.
No.
Nobody, don't work. Let us do one thing. Keep this matter pending till, which is the other matter where there is a challenge to this notice?
My lord, the matter is 3562 of 2020. This consolidated matter. There are a lot of matters. I've got the 3562 of 2020, and
Where you are petitioner?
I'm not a petitioner, but this
Then-
notification is that challenge, my lord.
So
This
what?
very notification.
If he is aggrieved by the gradation, he should have challenged the gradation.
We have not challenged the gradation list. We have not challenged the gradation list.
The consolidated gradation was under which I appear to be one rank below. My lord, that was published later when this 2020 notification was
State,
yes, yes.
this state,
This 2020 notification has been stayed under
where
which
is that order?
uh, 1, 2, 1, 5, 2. Page 1.
When was the gradation list made?
The recent one, the 2024.
And where is this matter? This matter was listed.
Before my lords, on 23rd it ought to be listed, but on last 23rd it was ought to be listed as per the last order.
No, no, today was this matter listed. Certainly. It was listed today. Item number 6. You have an interim order in your paper.
Did you pass the judgment?
Where?
24, 4, 25. Really, how to assess the seniority come merit.
Yeah, there's no quarrel with that. No quarrel. You are a computer typist.
I was appointed, yes, but I was appointed as LDM. He was appointed as computer typist. Now, when this computer typist post is not in the rules for us. The computer typist post is also not there in the rules for us. I was.
No, it has been broken. By way of an amendment, it has been broken. It's a part of the, it has been broken. Isn't it, Mr. Das? The post of computer typist then have been brought within the fold of the service rules of 87.
Yes, Lordship, page 20, Lordship, I have annexed in.
Page
20. Serial number 9.
Computer typist has been new designation in junior administrative. Now, this document is not the subject matter of challenge. 16th of September.
One of the computation gadget.
Now, Mr. Ichikedas, tell me what would be the effect of this order which has been passed in 1055? Now, 1055, what they have challenged is kindly come to this order by notification dated 4/3/2020 and 14/10. It was notified that the post of so and so shall be treated as equivalent to LPA copies package for the purpose of promotion. And since the pay scale of computer is the same of so and so, on the basis of the two, a common gradation list was prepared in the establishment of the response number 3 and use the response number 3. Response number 3 is the Borpeta. We are concerned with what?
No.
Well, how is this relevant? Goodness. State, you see the order which is being passed, directed as status quo. There's no stay to these communications.
When arising out of the same notification.
So what? There's no stay to these these notifications. What is saying? Maintain a status quo. Status quo has to be in reference to the gradation list which has been prepared in Borpeta district. It cannot be here. Chalo, we now allow it.
then my lord, on the second limb of my argument, my lord, the minimum criteria, my lord, where the district judge said that it was found not fit for the position, that he considered in this matter. Because if my lord
No, Mr. Counsel, you have to understand one thing. Seniority come merit normally means seniority will be given a preference. And when normally seniority is equal, then the merit will be looked into. But subsequent thereto, the judgments have evolved in more particularly in BV Svaya and all, wherein it says the seniority come merit would also need that there has to be a minimum requirement of merit looked into. Now, to look into the minimum requirement of merit, there has to be a benchmark fixed. Some benchmarks has to be fixed. Then look here, this is good. We will require have this 10. And out of 50 marks, 20 marks, 50 marks, 60 marks, something. And he did not get it. Okay. Now, what is being recorded here? Look. Having interacted with Mr. Abhijit Paul, it is found that though he is a graduate and he enjoys a good personal image, and there is nothing adverse about his integrity, yet he is not conceptually sound and considering the nature of work he will undertake as a senior administrative assistant in the office of the so-and-so. His keenness and diligence, as is required, is found wanting. His grading in ECR for the last 5 years have been very good for 2 years, good for 3 years. On an overall consideration of the matter, this selection board is of the considered view and resolves accordingly that Mr. Owe is not fit for to be promoted for the vacant post of senior administrative assistant. He may be considered later on acquiring better credentials. Mr. Saurabh Gupta is on the other hand shortlisted candidate for the post of senior so-and-so. As a corollary, Mr. Saurabh Gupta, candidate for promotion to the senior administrative assistant is considered. Mr. F appointed on there as LPA has been discharging his duties as such. Nothing adverse is found against him, and for the last year he has been graded very good for 3 years and good for 2 years. His MSc pass, his basic knowledge, keenness, and diligence as required is found very satisfactory. The selection board has found him to be a fit candidate for the post. Now, my question out here is when you are dealing with seniority come merit, you have a particular benchmark. If it crosses this benchmark, just for example, you put a benchmark of 30. This person concerned gets 31 or 30 even. You get 50 out of 50. Then also he gets it because of the fact it is seniority coming. This is a consideration which have not been taken into consideration. So therefore, they would have to again reassess by fixing a do it properly. Now, there is already a stay. The stay is not helping you nor him. So let them fix up mayor and do it. That's the way out.
Yes, ma'am.
It is win-win for you, win-win for him. Instead of keeping the matter pending by showing this particular order,
Agreed.
which have no relevance.
Yes, ma'am.
Where is my judgment? Instantly. Better judgments. And it is a short judgment. Hey, he, one of the matter says to that matter. A key appear person, a key Muhammad appear person. The repetition of that judgments. Kimatlo. Key Muhammad is a withdraw. Yeah, going. I think I better judgment. Let Mr. VP Bola also be satisfied with the good judgment. No, no, not this. This is the same judgment he's referring to. For Ubitra someone. No. The which one? Ubita Bola. They have detailed delayed dealt with. What is that? That is there also, I think. Not this. Which one? The task which AA. Victor Balabora. 2025. Yeah. I got it. 2025 SCC online GAU 4815. Paragraph 20 of the judgment. The proposition laid down in the case of BVCI therefore makes it abundantly clear that where the criteria of promotion is the principle of seniority or merit, marks can only be prescribed for assessment of minimum qualifying requirement. And as such, when the promotion is given to the eligible senior-most candidate on the basis of their individual marks, such promotion would be contrary to the principle of seniority or merit. Then I have the attempt to observe the judgment or another judgment. The judgment in respect to understood the another principle of a hybrid promotion. Hybrid. So this judgment is alive or dead? Mr. Das. Challenge? Not challenge, not set aside by the division bench. Upper division assistant now becomes SAR. And lower division assistant becomes JAR.
But as per page 20,
Page 20 is SAR
sir,
in 2024. Now, senior judicial assistant. Heard Mr. B.P. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. Gautam Boisha, the learned judicial department, J.K. Goswami. Mr. J.K. Goswami appears on behalf of the respondent number one. Mr. J.K. Gautam Boisha, the learned senior counsel, as well as the standing counsel, assisted by so-and-so, appears on behalf of the respondent numbers 2 to 5. And Mr. So-and-so appears for the respondent number 6. The present petition has been filed by the petitioner, assailing the order dated 2/7/2025, issued by the District and Session Judge Nagaon, whereby the respondent number 6 was promoted to the post of Senior Administrative Assistant, bracket SAR. It is the specific case of the petitioner that the criterion for promotion from the post of junior administrative assistant to senior administrative assistant is seniority cum merit, and the impugned order was passed thereby, which is contrary to the well-settled principles laid down by the Supreme Court. Insofar as the criteria of seniority cum merit. The brief facts which led to the filing of the present petition are that the petitioner was appointed as a computer typist against the sanction post in the office of the District and Session Judge Nagaon by an appointment order dated 28/8/2017. Mr. Counsel, today is a Tuesday. You can see. We are not in a hurry. We'll ask the judge slow. Pursuant thereto, on 14/10/2020, a notification was issued by the Register Administration, come in charge centralized recruitment, that all LDAs, typists and computer typists possessing the minimum educational qualifications shall be treated equally for the purpose of promotion to the post of UDA, bracket now SA. And a combined gradation list would be prepared. Subsequent thereto, on 16/9/2024, a notification was further published whereby 12 staff, where 12 staff, not staff, whereby 12, where the nomenclature of 12 posts in the district judiciary were redesignated. Pertinent herein to take note of that from a perusal of the notification dated 16/9/2024 at serial number 8, it would be seen that the UDA bracket upper division assistant was redesignated as senior administrative assistant. And as serial number 9, lower division assistant typist copyist computer typist were redesignated as junior administrative assistant JAR. In pursuance to the said, notification dated 16/9/2024 a gradation list was prepared whereby what is the name of the petitioner? Whereby
At page 27.
the petitioner was shown at serial number 25, whereas the respondent number 6 was shown at serial number 27. It is further pertinent to take note of that the petitioner was appointed on 22/1985. On 24/8/2017, whereas the respondent number 6 was appointed on 25/10/2017. 24/8/2017 and 25/10/2017. Subsequent thereto, a selection proceedings were initiated for the filling up the post of senior administrative assistant. Pursuant to a resolution adopted on 26/4/2025, the respondent number 6 was promoted to the post of senior administrative assistant by an order dated 2/7/2025, which is the subject matter of challenge in the present proceedings. The record revealed that this court, by an order dated 14/1/8/2025, 14/8/2025, after perusing the materials on record, more particularly the resolution dated 22/6/2025, state the impugned order dated 2/7/2025 and the said interim order which was passed have been extended till the disposal of the petition by an order dated 25/9/2025. The records further reveal that an affidavit in opposition has been filed by the respondent number 4 as well as by the respondent number 6. Replies thereagainst have been filed on behalf of the petitioner. From a perusal of the affidavit in opposition filed by the respondent number 4, the impugned or the decision to promote the respondent number 6 was supported. And on the ground, that after scrutinizing the materials by the selection board, the petitioner was not found conceptually sound and considering the nature of the work. The respondent number 6 was found to be more suitable. The respondent number 6 have also filed an affidavit in opposition, thereby supporting the decision to promote the respondent number 6 as well as the impugned order dated 2/7/2025. Next. The petitioner thereupon had filed affidavits in replies to both the affidavit in opposition, reiterating the petitioner's stand in the petition and denying to the contents of the affidavit in opposition. This court have duly heard the learned counsels appearing on behalf of the parties whose submissions made were in terms with their pleadings. And for the sake of brevity, this court is not repeating the same. Next. From the submission, from the perusal of the materials and report, as well as the submissions made by the learned counsels appearing on behalf of the petitioner, on behalf of the parties, the point for consideration herein, the point of consideration which arises in the instant proceedings is as to whether the selection committee, while evaluating the petitioner vis-a-vis the respondent number 6, have duly considered the principle of the criteria of the seniority cum merit in the as per the settled principles of law. Before dealing with the facts, this court finds it pertinent to take note of the judgment of the Supreme Court, in the case of B.V. Sivaya versus K. Adanki Babu, reported in 1998, 6 SCC 720, wherein the Supreme Court explained the difference between the principles of merit cum seniority vis-a-vis the seniority cum merit. The Supreme Court observed that when it comes to the principle of seniority cum merit, the promotion is to be made on the basis of seniority alone, subject to having the minimum requisite merit and suitability of the candidate amongst the eligible candidates. The Supreme Court categorically observed that the criterion of seniority cum merit postulates that given the minimum necessary merit requisite for the efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. It will further observe that for the assessing the minimum necessary merit, the competent authority can lay down the minimum standards that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service records and interview, and prescribing a minimum marks which would entitle the person to be promoted on the basis of seniority cum merit. The Supreme Court further emphasized in the said judgment that while taking into consideration the principle of merit cum seniority, the requirement is making a comparison of assessment of merit. This court also finds it very pertinent to observe that from the propositions so laid down by the Supreme Court in the case of B.V. Sivaya, it makes it abundantly clear that where the criteria of promotion is the principle of seniority cum merit, marks can only be prescribed for assessment of the minimum qualifying requirement, and as such, when the promotion is to be given to the eligible senior most candidate on the basis of their individual marks, such promotion would be, and as such, when promotion is given to the eligible senior most candidate on the basis of their individual marks, such promotion would be contrary to the principle of seniority cum merit. In the backdrop of the above principles, this court finds it relevant to take note of the resolution dated 22/6/2025 and the manner in which the selection committee proceeded to adjust the evaluation of the petitioner vis-a-vis the respondent number 6. The relevant portion of the resolution being pertinent to the issue is reproduced hereunder. Item number 2. From a perusal of the above quoted resolution, in respect to resolution, it would be apparent to see that the selection committee even did not consider of fixing the minimum benchmark which would be taken into consideration for adjudging the merit, insofar as the same is requisite for efficiency of the administration. From a perusal of the minutes of from the perusal of the above resolution, it would be seen that there was a comparison of merit vis-a-vis the petitioner with the respondent number 6, which is a concept permissible when the criterion is merit cum seniority and not seniority cum merit. Considering the above, it is therefore the opinion of this court that the resolution so adopted on 24/6/2025 by the selection committee to select the petition respondent number 6 on the basis of seniority is contrary to the settled principles of law as regards the criterion of seniority cum merit. Consequently, the promotion which have been made to the respondent number 6 is in violation to the provisions of section 6, rule 6, 6.3 or 6.4? 6/4. 6/4 of the Assam district. What is that name?
36.
What is the name of the act?
It's the Assam District and Session Judge Establishment Ministerial Service Rules 1957. This 36 it is quoted.
6/4, no? How?
6/4.
6 years.
Page 36 it is quoted. One of the pretty.
6/4. Accordingly, the impugned order dated 27/2025 is required to be interfered with. The instant petition according stands disposed of with the following observations and directions. The impugned order dated 2020 or 2, by which the respondent number 6 was promoted to the post of senior administrative assistant by the respondent number 4,
Yes. Respondent number 4, District and Session.
is set aside and quashed. Number 2, the respondent number 4 is directed to fill up the post of senior administrative assistant by applying the criteria of seniority cum merit, and by taking into account the observations made herein above. The same be done forthwith and preferably within 2 months. 3 months. 2 months. The records which have been produced. This is a photocopy of the said record. You give a photocopy, yeah? Proceed. Photocopy of the records so produced is kept on the record for future. It's kept on record. A photocopy of the resolution dated 24/6/2025 is kept on record and marked with the letter X.
What the corrective law? You can use photograph minor of the paper attached to the same. Like for some application of the
Attachment will be remain. Attachment will remain, but they will see. Yeah, attachment will be remaining, but they will only see. Sealing has been,
Sealing as well.
but they will be seen.
They'll be seen. Let it be in the next that you'll not see that.
They will see it, and they is what?
30th.
30th. 14th November, 14th May, we are having the matter again. On that day, 15 lakhs.
But pay for 10 lakhs, madam.
No, 10 lakhs.
But I have undertaken to pay. Madam.
No, you are not, you are undertaking. Undertaking is only permissible. I give you 3 months. If it is, it's a duty withdrawal to give the Make it very clear, Mr. Saslam. You see, the problem is the person you are being engaged by a person to say something.
What?
They're a lawyer. You have been engaged to say something. If you don't trust your client, how can I trust?
No, my lord, I am making this submission on it. Yeah. Not a case.
So tomorrow, therefore, tomorrow, I have seen many cases where I have been out there.
This is not happening.
Even undertaking what happened later on. That he doesn't honor. If he doesn't honor, then the lawyer will say, I can't help it. So therefore, okay, we do until 14th, and then the next date is on 28th of May. 28th of May. Okay, we make it 14 lakhs and 13 lakhs. 14 lakhs and 14 lakhs.
But 12 lakhs, some respect. First installment.
14 and 13. It is 47, right? 46.
What is
14 and 15. 15 and remaining 13 will be 46 like 32,000. That will be a remaining.
Well, that is all right. I am only.
Person is fighting out there to get a money which I think cost us to be paid.
In fact, your lordship, if I may say, his father was a retired employee. He is an orthopedic surgeon. He has to leave his job and come back. His father, when he retired, has submitted the entire money for purchasing the flat, although in white, not in black. And his father used to go every day, but every week, in fact. And he had died of a cardiac arrest while returning one because this lady behaved very well. Thereafter, he lost his elder brother also. I don't want to draw that sympathy, but I'm saying this is the plight of a lower middle class family. What happens here, lordship? This money is of no use for him right now.
On my side, my lord, there was a long period of time taken in removing the high, my lord, taking the power, my lord, electricity line. That 33 kV line, that had to be removed, my lord. That came about 2.5 years down there. Then, my lord, the COVID times came.
All wrong submissions.
This is not.
All wrong submissions. Yesterday, submission was made that the school books was inside.
Right. It is for now.
No. Yes, that is for now. His daughter is studying somewhere in aeronautics. The order of the RERA is at page 34. Your lordship, it starts at page 34. And the operative portion is at page 42.
So, page 42, 22A is not applicable anywhere. But you made a submission yesterday that it will due the month of July or August you are going to pay.
July 3rd.
You are not, you need not leave it. Because 24A is not applicable. So it has to be 24B. And if he pays 42. That's all. If the promoter fails to hand over the flat within the prescribed period, then the promoter is directed to return the principal with applicable interest as provided under 17 and 18 within 45 days. Rate of interest payable by 12 is the rate of interest by the year to the levy of the advance 12 shall be the State Bank of India's confident for lending rate plus 2%. Provided that in the case of failure of lending rate here, the operation is obtaining the American state. So 25 is not applicable. With regard to the compensation, the complainant may approach the adjudicating authority. The 31 filing a special complaint for non-exposed will. It is, then what is make 2510. Or this is the calculation. 46,32,000. This was found in 2023.
Yes, your lordship, 25/10/2023.
So what about the interest subsequent thereto? Mr. Goswami, what about the interest subsequent thereto? Should ask the particular to again recalculate. Because the payment has not yet been made, payment has been calculated up to 27/1/2023.
Yes, your lordship.
What about the other 3 years?
No prayer, money.
Huh? Okay. We adding?
Yes, your lordship. It is 226, your lordship. In fact, I was about to make that.
Big loss, madam, in this case.
No
No,
loss.
kindly, madam, he has also not said he is not pressing it, madam. He is actually pay, madam, that certificate amount, madam.
Mr. Goswami, I'm telling you, you won't record it in the order now. If you violate this order, if you don't pay this 14 and 13 by next 28 days. Telling you, next 28 days, if you don't pay it, I'm going to impose it. Tell your client to go.
I'll do that.
think some indications will be given. Yes, the function. Heard Mr. Goswami, the learned counsel appearing on behalf of the applicant who is the respondent of applicant's group, who are the respondent numbers 4 and 5 in the accompanying with petition. Mr. Archina appears on behalf of the respondent of the appears on behalf of the petitioners. The present application has been filed seeking stay of the order dated 27/4/2026 passed by the Circle Officer, Dispute Revenue Circle, as well as the issuance of warrant of attachment of the immovable property dated 27/4/2026 issued by the Additional District Commissioner, cum certified certificate officer, Kamluk Metro. Mr. B.D. Goswami submits that in pursuance to the order dated 27/4/2026 passed by the Circle Officer, Dispute Revenue Circle, as well as the warrant of attachment of the immovable property belonging to the applicant. And in pursuant to the warrant of arrest, attachment of the immovable property issued dated 27/4/2026. The property, the flat of the flat number.
This is not, this is building.
No.
This is residential, your,
My flat number, your lordship.
mine is house number 86. House number 86, but in lot number 1 of
The house of because we have to specifically direct, the house of the petitioner, it will be there in the order, attachment of the
15 of the circle number.
the building of the petitioner, of the applicant, standing over the plot of land at measuring. Plot of land at measuring 6.70 R, covered by that number 1084 of KP Patra number 800 of Rukmini Town, Moja Belpola. in the district of Kamrup. Which is specifically mentioned in the notice dated 27/4/2026 issued by the circle officer. This two revenue circle has been sealed. The materials of report show that this court, before taking into account the case made out by the applicant, finds it pertinent to take note of the facts which led to the filing of the present application. A deed of agreement was executed on 28th of November 2013 between the applicant along with the petitioners in the applicant along with the petitioner in the petition number 5921 of 2025 for sale of a flat specifically described at Schedule B to the agreement dated 28/11/2013. In terms with the said agreement, the flat was to be handed over to the petitioners by within 3 years, isn't it?
Yes, sir. That is 3 years.
However, as the flat was not handed over and various requests were made from time to time, the petitioners were compelled to approach the Real Estate Regulatory Authority Assam by filing an application which was registered and numbered as case number RERA/ASSAM/2021/1/48. The said proceedings was disposed of by an order dated 27/1/2023, whereby the applicant herein were either directed to hand over the completed apartment within 45 days from the date of the issuance of the order, or to pay the principal amount with applicable interest as provided under section 17 and 18 of the Assam Real Estate Regulation and Development Laws, Rules 2017 within 45 days. Admittedly, the flat in question was not handed over to the petitioners, and resultantly, on 25/10/2023, the chairperson and member of the Real Estate Regulatory Authority Assam passed an order holding inter alia that the petitioners herein were entitled to an amount of rupees 46,32,835 in terms with paragraph number 24B of the order dated 27/1/2023. It may not be out of place to mention that till date, not a single penny have been paid to the petitioners pursuant to the order dated 25/10/2023. And further to that, it is also pertinent to observe that the interest was calculated as on 25/10/2023. On account of non-payment of the amount as adjudged by the order dated 25/10/2023, proceedings were initiated before the Bakidai officer, certificate officer, in the office of the District Commissioner, Kamrup Metropolitan District. Notices were issued to the applicant for payment of the said amount. However, the applicant hearing thereupon appeared before the Bakidai officer and filed an application on 3/4/2024. Thereby seeking a period of 3 months' time to pay the total amount to the petitioners. In spite of such undertaking given by the applicant before the Bakidai authority, now, on the basis of such undertaking given by the applicant before the Bakidai authorities, the Bakidai proceedings were stalled. Resultantly, the petitioner again approached the chairman of the Real Estate Regulatory Authority by filing a petition as regards the non-compliance with the order dated 25/10/2023. Thereupon, again, the proceedings were initiated before the Bakidai officer. The applicant thereupon again appeared before the Bakidai officer on 29/7/2024 and submitted another application wherein at paragraph number 9, the applicant had stated that she had issued 2 post-dated checks dated 30/8/2024 of an amount of rupees 20 lakhs and another post-dated check dated 30/9/2024 of an amount of 26,32,835. Copies of the said checks were enclosed in the said application before the Bakidai officer. Basing upon the said checks, the said Bakidai proceedings were stalled. It may be, however, relevant to take note of that both the checks which were issued by the applicant were dishonored on account of insufficiency of funds. The petitioners thereupon again had to request the Bakizai officer to initiate proceedings. However, there being a delay in such proceedings, the petitioners have been compelled to approach this court by filing the present petition. It may not be out of place also to mention that the petitioner also approached the real estate regulatory authority, intimating that both the checks which have been issued have been dishonored, and the real estate regulatory authority by the order dated 39/2024
So I was directed to accept the next check also. By this order, the RERA directed me, I have informed that the first check got dishonored. So what I need to do? Now the RERA passed this order saying that, okay, you go and accept the second check. And if it gets dishonored, you inform us. And in fact, I have been informing the Vakijai officers also from time to time, but they have not initiated any steps against.
I don't think we require this. By filing a petition, which was registered and numbered as WPC number 5446 of the 2024. The learned court made bench by the order dated 28/3/2025. Close the said petition. On the basis of the submissions so made by the learned state council, that steps would be taken by the Bakizai officer in the manner by the Bakizai officer. However, in spite of that, the records further revealed that the applicant thereupon had again filed another petition before this court, which was registered and is numbered at 226 of the 2025. And this court, while issuing notice passed certain interim directions, subject to deposit of a sum of rupees 20 lakhs by the petitioner before the respondent number 3 within 10 days from the date of the said order. However, the said amount was also not deposited. Mother died when? On the very day, they could not take the report. Petitioner thereupon, the applicant thereupon filed another petition before this court. No, the applicant first thereupon apprised this court thereupon it is further seen that by an order passed by this court on 21/5/2025, the repetition so filed by the applicant being the application number 2226/2025 was dismissed on being not entertained. The records further reveal that in the meantime, as the proceedings before the Bakita officer was proceeding in a snail's pace, the petitioner have approached this court by filing the present petition. It is further seen that in pursuance to various orders passed by this court, more particularly the order dated 25/3/2026, the warrant of attachment of the property has been issued by the additional district commissioner cum certified officer, certificate officer Kamrut Metro. And a notice was issued by the of the same date was issued by the circle officer, dispute revenue circle. On the ground that the petitioner's property, applicant's property has been seized, the present application has been filed. Mr. B.T. Goswami, during the course of the hearing, have handed over a check, a demand draft, drawn hearing number 500165, drawn on the ICICI Bank, Gauhati Patasi branch, favoring the petitioner number 1 up to Mr. R. Sinha, the learned counsel appearing on behalf of the petitioners. A copy of the said check, a demand draft, have been also placed before the court, which is kept on record and marked with the letter X. This court is of the opinion that in view of the handing over of the demand draft, the petitioner applicant is entitled to certain interim directions subject to fulfillment of certain conditions. Number 1. This court is not inclined to stay the warrant of attachment of the immovable property dated 27/6/2026 issued by the additional district commissioner cum certified officer Kamrut Metro. This court is further not inclined to stay the order dated 27/4/2026 passed by the circle officer, dispute revenue circle. However, this court directs the respondent number who has sealed it.
Sorry, sir. Cannot be, it is Bakita officer, my lord, it's a other, quick police.
We have not made the circle officer party. Into that act. Why he should make a party? You should have make a
My
party.
lord, you have not been notified, no notice was.
Not necessary. You want to stay for that, you should have done it.
My lord, because, my lord, very, the hurry was too much, my lord, the house was sealed all of a sudden, then I had to come, my lord.
Your house was not sealed, houses of the.
But it's my client's house only. Yeah, near the any time, my lord.
We direct the additional district commissioner.
Yes, my lord, he's appearing for the particular.
However, this court directs the additional district commissioner Kamrut Metro, who is also the district Bakita officer, to deceive the building of the petitioner, which is situated, the two-story building of the petitioner, which is situated over the plot of land at measuring so and so in that number so and so. The additional district commissioner come with metro. He is also directed to inform the circle officer of the district revenue circle, as well as the officer in charge of. Oh, okay. You have to give the officer in charge of the hotel book post only.
The IA.
Pretty sure we could. Because don't come up and say that, okay, doing the.
Well, your lordship will kindly come to the page 14 of that IA, madam, warrant of attachment that was issued, addressed to dispute.
That is the dispute area and well as the officer in charge of the dispute registration. To deseal on the basis of the order passed during. The same, the aforesaid order. Is however subject to the following conditions. Number A, the applicant herein shall further shall produce a demand draft from a bank from a, from from a scheduled bank before this court on 14th of May 2026 in favor of the petitioner one. Yes. Of an amount of rupees 14 lakhs. Number 2. The applicant shall on 28th of May 2026 produce, placed before this court, another demand draft from a scheduled bank drawn in favor of the petitioner number 1 of an amount of rupees 12 lakhs 32,835. It would make clear that in the circumstance, the petitioner, the petitioner, the applicant hearing is put to notice that in the circumstance, the conditions which have been mentioned herein above at subclauses A and B are not complied with. The property in question which is under attachment shall again be seized. This court further would consider on payment of the entire dues as to whether the the petitioner's hearing would be entitled to further interest, taking into account that the interest was computed only up till 25/10/2023.
Let me carry out this exercise. Your lordship has yesterday indicated that they need to file a detailed affidavit indicating their property and details everything.
We consider later. That property is there now. I have not removed from attachment. So the attachment is there. We will sell off the property. But that is not there. This I have put it out there for you to convince your client that if you don't do so, this court is going to be.
It is to be listed only on 14th.
It's the matter on 14/5/2020.
For further hearing. For further hearing, your lordship. Deeply applied, your lordship.
Much of less.
Ekon, my devoted. Mr. I will do one thing, Mr. Goswami, I'll ask him to give a copy, he will give it to you.
My lord, yes, I have no copy of the petition. This order copy, madam. Yes.
This order copy, because you may not get the certified copy. Ask one of your juniors to you. So if taking into account the urgency, this court directs the courtmaster of this court to provide a true copy of the present order. And the respondents, and the additional, the district Bakizai officer come the additional district commissioner so and so shall act on the basis of the same true copy of the order. Right. That is right. Yes, yes.
This is a matter of removal. This is a matter of removal. The petitioner was a peer at the office of the CJM at that time 6 ago. So the allegation, statement of allegation is at page 16.
Oh, this one. Yes.
Take copy.
You don't need to follow. Yes. What is this? You know, the case that has been projected before the lordships is that innocuously that he was absent during COVID period for a few days, and accordingly he was dismissed from service or removed from service. But I have filed the affidavit wherein I had projected the case. Let's see. No. Yes. Our case is that. Well, let us see your charge sheet. Yes, ma'am. Charge. The charge is also incorporated. Page 15. Yes. Charge. Yes. While working, that you while working in the capacity of PM in the office of the undersigned remained absent from your duty without any intimation or any form of authorization. No. Kindly come to page 11. Page 11 is the show cause. That is the charge. No, charge sheet is different, madam. Page 15. Page 15. Okay. Initial show cause. Okay, let us read the statement of allegations. Yes. Page 15, my lord, will kindly help. You while working in the capacity of peon in the office of the undersigned remain absent from your duty without any intimation or any form of authorization from this office with effect from 1/6/2020 to 6/7/2020, excluding the de-rostered days and also till 16/7/2020 after issue of show cause notice. That you while working in the capacity of peon in the office of SDJM Najira were absent from duty on 3/4/2017, 2/6/17, 6/7/17, 10/7/17 unauthorizedly, due to which you were suspended from service pending departmental proceeding, and on conclusion of the departmental proceeding, you were barred from drawing one annual increment without cumulative effect as a punishment, and you gave written assurance that you would not do such acts in future. That despite your written assurance, you again unauthorizedly remained absent from. No, wait, me. On conclusion of the departmental proceeding. Yes, okay. So let me, in respect to that, you have already imposed panel. penalty.
Yes, and there was
Because
assurance.
if it is a case for compulsory retirement, this is the conduct which can be looked into. But this is not the thing which
It's a-
can be a case of a child.
Yes. Basically, what they have, Milord, considered the past misconduct also while deciding this procedure.
But now
That
I
despite your
understand here, now the allegation that is 16 times that you even after the two
Departmental proceedings against you, suspension from service, consequence punishment, and repeated written assurances from you that you would not do such acts in future, again remain unauthorizedly absent with effect from 1/6/2020 to 6/7/2020, excluding the derostered days and also till 16/7/2020, and thus once again acted insubordinate and remained absent from your duty unauthorized. So our case is that, my lord, it's a case of, my lord, habitual absenteeism.
How can you say this is peak COVID period?
No, yes, no, true, it's a true. May I just explain? My lord, it's not that case in the establishment.
Okay, reprimand. This is the best case of censure in modern politics. But we have already done implementation now. But this is the time of COVID. Yes, they are not the first. These people were not also the from political COVID warriors. No, COVID warriors. COVID warriors. You can't bring them also within the ambit of COVID warriors. If I have to obtain this type of punishment out here, tomorrow maybe the division bench may not do. But this sort of a solid picture in the state of affairs of the Indian judiciary.
Sir, if I have understood,
I means the yes. On well other days you do it.
no, normally
But
it's
this was a peak time. This was a peak time from 1/6/2020 to 6/7/2020.
absolutely.
I
no
still
doubt.
remember, I tell you one thing, the best part was this, sometime the COVID started, the Thursday was on 15/3/2020. Then first 1 month goes, then the second month goes, second month on 30th of April or something, the court started on hybrid, no, so some hybrid thing, where the lawyers had to come for the first time. The lawyers had to come. And the judge used to put his mask in his home and read something to the effect, or in the chamber it was done. Thereupon, after 5, even a lawyer moving around in the street, again he has a problem. Because you see, the lockdown at that point of time was still 5 o'clock. Yes. It was relaxed from 8 to 5. And thereupon it was done. Now, you see, that was the situation which continued till the month of August. So the first part of August, sometime like that, it was relaxed partially. So we are concerned out here during the period from 1/6/2020 to 6/7/2020. This was the peak. Yes, do whatever you feel like. You pay 1 increment, 2 increment, whatever maybe you have already done so. But to have any major penalty at this stage,
Look, what I have understood is that, my lord, normally in the district judiciary, look, major penalties are very rarely passed. But in this case, what
you see,
I've seen the
yes,
records, my lord.
I'm sorry. Well, you see, that is why I'm sorry. I need not go to any others. The fact is, this is the so-called paragraph 16, page 16, that particular first paragraph.
Yes.
Because you see, you have already imposed certain penalties in respect to the earlier two.
Look, may I just explain one thing? It's true that with respect to the earlier penalty, earlier my lord, allegations or misconduct or insubordination, some penalty has been imposed. All were of unauthorized absence. You know, what I'm trying to impress upon your lordships is that, you know, it's not a case that only during that period you were absent. there were past conduct also where he remained
Understood, the
absent.
past conduct understood.
And
There's no quarrel.
it cannot be a case
Mis-
that this,
Mr. Das, if it was a case after of September 2021. September 2021, I'm saying, because that was the second year, 2021. If it was something to that effect, let us say that okay, do
I-
something.
yeah, just, I'll
You,
just,
you can do.
I'll just add
But
one
here
aspect.
you have already, by issuance of this charge sheet, you have already taken up, you have a preconceived mind that you see he's a habitual here.
No, in the show cause, in the charge sheet, it doesn't reflect that there was some preconceived
It
mind.
is apparent.
No.
Why, no, you
I'll
see,
just explain.
no, Mr. Das,
I'm sorry.
I hope you will consider this, that this would have duly taken on many disciplinary. True. In the disciplinary proceedings, if you are going to go for any imposition of alia, yes, these are the things which will be taken into consideration in the second show cause notice. First show cause notice, you will see whether it's a case of insubordination. We have passed an order, is it a case of insubordination? First show cause notice. Yes. Then you find out, yes, there is a case of insubordination made out. Then you say, why we should not impose the alia, because in the earlier occasions also, this is there, and therefore you impose the penalty. This is how. But how this is being made? Here you say that you see in 2017, this has happened, we impose the penalty. 2018 is happened, we impose the penalty. And in 2020, this time also you have done, and under such circumstances, why you should not be charged of insubordination or the absence of duties and all. And they don't belong to the discipline service. I would have understood. I don't think even the nurses or the world boys who were present out there would have been taken an action of this magnitude in the case during the COVID period. People were worried at that point of time. People could not think about it. They think that if we go out anywhere, we will die. I saw that day a movie, some lockdown or something. Fantastic movie. Of course, these were the the two boys. In fact, this matter, this movie went to the Oscars. These two boys who were there, they were working out there in Bombay. Now, while coming back from Bombay, because they were laborers out there and there was nothing out there, the food was not available and all these things, so they had to come back. While coming back, they entered all these people hired a particular truck. Around 70 or 80 people were inside the truck and they were coming. While coming out there, one of these boys sneezed. And he was thrown out. And both of them were sitting on top of the car, of the area, and they came over. And in the meanwhile, one of the boys expired. So, you see, the state of paranoia, this person was happy. All the people were having. Why should I save my job or should I leave? This was the state of
Lordship is absolutely correct. Had that been the situation, Miller, I would not have uttered a single word before your Lordship. But I have annexed the rosters of that period. He was not the only employee in the office, Miller. There were around 15-20 employees who were allotted duties in a staggered roster. All the employees, they duly came to the office.
The question of if we order him here, that may again happen another time. You may repeat all these things. All these things will not come because the COVID is the
No,
one time
what I'm
fair.
trying to submit is that, Milord, all right, he was unable to come, but are we not required to see the plight of the employees who came during that period itself regularly to the office?
Yes, that is why the government is giving the 45 lakhs, isn't it?
No, that's
Any
true.
person who
But
dies.
Why
45
why
lakhs.
he is the only person who was unable to attend the office for those days?
But
And-
does it amount to termination?
But I'll just come to that. Milord, I'll come to that, Milord. Milord, I'll come to that. But the question I am asking myself, why he? And Lordship will see the
conduct of the petitioner, all other employees, they were regularly coming. And not only this 2020 incident, my lord, I have annexed in my affidavit, there is another incident of 2023. Again, he remained unauthorized layer. So take an action on that. So that is because that is not part of the subject matter. Action was taken, but despite that, I have also seen many TPs, Lord. Hardly in district judiciary, this type of penalty is imposed. They don't take out the job of the person. But I think in this case, my lord, the
not on the basis of
was
discharge.
annoyed.
No,
Disciplinary authority
that's not on the basis of this. You may take an action in 2023, yes, done, you take an action, you may do it, and I would not have interfered. But on the basis of discharging for this period from 1/6/2020 to 6/7/2020, when it was.
Roxy will kindly have a look the roster.
Let
I'll
us
just
show.
show.
Let us review all judges, everybody come. But then also, can you impose upon him that you give up your life and come? No. As of now, just for example, at that point of time, why you were having in the court out here, where you were having the judge would be sitting inside, while the lawyer was coming outside? Why? Why was it necessary? If the lawyer has to face the death, he's also under a peril.
He's also a human
Judge
being.
also have to. What is the necessary? Why this was being done? The file of the lawyer was not sanitized. Whereas the judge's files were sanitized. I was a lawyer then. I've seen it with my own eyes. But the fact remains that there were matters which were there which required urgency, for which it had to be taken. How many times now? Let us
Despite
take
the
let us
lockdown,
take one thing. No, let us assume one. This is a case which has happened. What do you say about the order passed by the court, Supreme Court, on 10/1/2022, extending the period of limitation? Why? There are a lot of people who must have lost out their defenses for 3 years, from 15/3/2020 to 2028/2022. This was the limitation which was taken and not that. The limitation was in 28/5/2022, 31/5/2022, the 90 days thereafter. Why was it given? These are things being given because it was at a time when it was not a thing which was experienced. This was much prior to at that point of time. Those in England you used to have the plague. Here's something to that effect. How you can put the punishment like this? Yes, anytime later on you can very well put it, but not on this. My conscience is not. That is why I said not the same. I will argue on it.
But from the records, what I have understood is that other employees,
Not on the
they
basis of
started,
discharge.
they work. And
Understood. Everybody
ultimately,
was.
Lordship will kindly appreciate,
You
we
see-
have to run
you see-
the
you
institution.
see-
Even it's a lockdown.
No, no,
since
just like
hygiene
that.
was functioning, the district judiciary-
Let me give you another example. While I was sitting in Kohima, not this time, the last time we were there, the day that sometime in November, yes, sir. At that point of time, there were no nurses, no doctors, even willing to come to the hospitals. Nothing. The government came up with a plan that look here. Anybody who comes, we would regularize them. We would bring them within the fold, give them a job. Irrespective of where anybody who works, even in a private hospital, also,
They came.
no. They also, if they work in the private hospital, nursing home, that will also, then also we are going to begin. The reason is
Service.
nobody was coming.
Service.
This is the state of thing. Then some persons came.
And then later on, the government took the decision that no, only those people who have been appointed out here will be given, not the others. They play huge implication. And then you people were accommodated. Because there was no person who was willing, like, no particularly doctors and all. Nobody wanted to come. Why? I have seen, you must have seen an serial. There were two things, serials which were pertaining to the USC, pertaining to the doctors. One was with the doctor.
Yes.
One is Grey's Anatomy.
No, Grey's Anatomy is the new
Then
one.
One was this, what is the, I just forgot. Doctor, who was from this doctor was suffering from autism.
Yes, this one. Fair boy. Yes.
Then also, if you see, what in each of these cases, when they were showing after 1 year, there was a gap because these are regular series. 1 year there was a gap on account of the pandemic. Thereafter, what was happening was when they showed this thing, one episode they dedicated to the doctors. I think we are having a problem with doctors. They could not go inside the home. They were asked to come. They used to stay in the garages and then go down. No, nobody was that. And nobody could come into that. You see, forget about that. At this point of time, tell me one thing. If a person sneezes in Gauhati, at this point of time when you have terminated, he was active. If a person sneezed at Gauhati, he would have been put him in those camps. I would say to be camps and given a bucket, a towel, and one soap. Was this not the state of affairs? And now you say that you are going to punish him with this hour.
Consciously, my lord, consciously, I would not have done this. But the problem, what I saw is that
Then for any other period, very well fine, but not this period.
may not be removable, but if he improves himself, then my lord, some other
You
penalty.
take action for the 2023. Take action. Not in this.
They have taken a lenient action in 2023. my lord. And
23, I'm not concerned. That is not the subject matter before me.
not true.
My action is, my action has been taken. He was terminated on the basis of his action. Yes, there was an
Can we appreciate likewise the hospitals are functioning, the district judiciary will also have to function. And without the employees beyond, how a district judiciary will function? So
Mr.
that's what-
Das, tell me, did you get the first dose of COVID vaccine? Did you get it? How? Were you a COVID warrior? No. It was only given to the nurses and doctors. Because you are not the COVID warrior and paramedics. You don't belong to that strata. So therefore, if you are not the persons who you even get the COVID vaccine for the first thing, yes, then you are not protecting them. I think these people should have been more sensitive.
I think they also would not have imposed removal. They also would not have imposed removal. It actuated because of his fasting.
His past has to be different. But you could not have initiated a departmental proceedings like this.
No, so far as past
You have so
misconduct
much
is
of time to initiate departmental, other departmental proceedings.
not, so far as past misconduct is concerned, in a subsequent situation, below allegation or incident,
is subsequent.
no. Past misconduct can be included. There is nothing wrong in it. If a, in the
Past-
matter of
Past
No, suppose I am
misconduct can be, no, past misconduct can be, not only misconduct, it is a punishment.
yes, can be
You
included in a
have, you
subsequent
know, you
charge.
had disciplinary proceedings. One, not two. Two disciplinary proceedings you have, and you have imposed punishment upon him. That can be a factor at the time of punishment.
Yes.
There's no quarrel with that. I'm not on that. But the question is, could you have initiated a discipline proceeding for discipline? No.
This period.
This period, 1/6/2020.
But so far as past misconduct,
Past
that-
you do, but you have already imposed.
no,
No,
even
no,
after
no,
the
no,
penalty-
Mr. Das, kindly
I'm sorry,
explain.
I'm sorry, I'm sorry.
For the past 1 and 2, you have already imposed punishment. Now, if the third one, this period, you cannot do so. You cannot do so. The initiation of the Department of Proceedings is back at that point of time. There would be. Then you do what you mean. Yes, for 2023, if he has done, you do whatever you feel like. I'm not on that. But this period, I cannot.
No, I urge upon your lordships to consider the matter in the manner on the. No, I'll.
You are what? Beyond. Beyond.
Yeah.
You impose a cost upon them as compensation for the trouble you have done. 1 lakh.
Cost may not be imposed.
No, compensation. Cost will be. You are to pay compensation. What the trouble and turmoil for engaging us, counsel like him. This court is not going to allow. This court, I would have, on the first day, I would have allowed this. But the thing that you were there on that day, so I said that, okay, let the Gauhati High Court have the pleasure of filing affidavits. Although they, 2024, they don't file, and 2025, they file.
Lordship can consider in the.
26,
Proportion.
2026. There's no proportionality question. There is the initiation of the Department of Proceedings.
Milord, even if he absented
And
without
how
any
many
permission.
did you-
Milord, only 1 second. Milord,
Wait,
only one thing.
2020 to 2026, you have put him under mental agony. 1
No.
lakh is less.
Milord, if he was unable to perform duty, was it not his responsibility to send a communication or a message or a phone call? All the evidence during the inquiry, all the witnesses categorically deposed that he never communicated anything, that he was having some problem, he was unable for COVID. All the deposition of witnesses were there. I'm not vouching for the penalty imposed. But in the backdrop of those evidence, there was no communication from me. I'll forget about leave application. Not required. If you are
Did you,
taking
did
this
you then, if that be so, did you go into the question of a deserter?
deserter in a army act
Deserter
of-
then.
no, it's a
Deserter, but the deserter is not a punishment.
in a disciplinary appeal rule, there is no concept of deserter. But I'm
Did you
asking
issue a
myself,
notice to him? Prior to initiation day that you have not appeared, have you issued a notice to him?
a so-called notice was issued to him.
No. To him to have come. Because you didn't also have the peon to go and give it to him. Where's your peon?
No,
No, where's your peon?
no, he was the peon. He was the peon.
No, to give it to him. You also didn't have anyone.
How? Not when he was not there. How? But these are
But-
elementary things.
So you were
I
dependent
understand
upon
he's
him.
taking a plea of the period, fine, Milord, no problem. But the thing is that those things are there in the evidence. That's why, Milord.
1 lakh less. 6 years. 6 years the thing. No, you are still dismissed.
Yes.
Oh my goodness.
By virtue of order dated 23.
Reinstated. Wait, no,
He
all
was-
back wages.
He was penalty imposed was
23. The order was passed in the year 23. 3 years.
3 years. Reinstated with back wages.
Madam, that is my prayer.
no removal order, my lord, 5324.
53.
Thereafter, the appellate authority's order is 19725. Penalty order, page. my
Was
lord,
there
you
no
find
stay?
Page 53.
Was there no stay?
No stay.
Because already have been removed.
He approached this on 26
So you have imposed him when?
of 5324. Page 50.
Page 52.
Page
The
53 is the
question calls
relevant
for
one.
consider whether the include order will be a sustainable argument.
Then he preferred an appeal.
Cross examination. What is it? Renders into.
No, he has annexed the evidence of the witnesses also, wherein the witnesses categorically deposed that there was no intimation.
Servant conduct inside in an instance. appeal was disposed of. I think the gentleman. 1970.
Appeal was 19/7/25 is the appellate order.
What is more interesting is that the inquiry authority had passed the final order at page number 49. The inquiry report, and they had passed the final on the foregoing. Then come inquiry authority. They had passed the final order. Final order execution needs to be passed, but the way of final drafting. Inquiry officer draft the final. Where is the termination order? Page number
53.
53.
Starts from
52. This is a page of 2 pages, and the appellate order is of at least 10 pages. Okay, now did you ask him to submit a representation?
Yes.
After the appellate order, no.
No, after the inquiry report, he submitted the representation, page 50. I humbly accept the finding of the inquiry officer. I beg to pray before your kindness to excuse my fault for the last time. I hereby assure.
The division bench is very kind for the high court. You can.
He has admitted in his reply to the inquiry report.
No, I say that let him admit.
Yes.
That he was present, not present. Let him be. Then also. we
I
should
under-
not have-
I understand the lordship was on the period. That's true.
Any other case we would have considered, any other case of discipline service we would have considered. Even the army would not have done this. That is correct.
It has happened because of the past thing. Nothing. I don't.
Why were you thinking about the past in the Supreme Court?
There is in fact no legal harm. It can be taken up.
Yes, you can very well do it. You can very
can
well
be
do
taken
it.
up.
It's supposed to be a preconceived.
No.
Yes, you should have taken up.
With all due respect, Lord, past conduct can be taken up in a show cause notice. It's not that cannot be. No,
No, what do you do?
in the charge sheet itself, it can be
No,
taken
no,
up.
what, where you placing, where you further adjudicating a form or asking for an inquiry in respect to the past misconduct. When you having an inquiry in respect to the past. No. You were having an inquiry into the present misconduct, you started from 1/6.
Lord, in the present misconduct itself, a reference can be given to the past misconduct, saying that previously
Yes,
also you
at
have
the time
done
of
this,
punishment. At the time of punishment, no, very well we can do. Yes, indeed. Your actions are such that we are not doing. Just for example, when you were acting in the year 2023, you could have very well say that these two have happened. Here we have not taken anything, but here in 2023 also we have done this. Okay, you are very well. The moment he comes, I will dismiss him without issuing for notice. Yeah.
so far as period is concerned, my lord, I leave it to your lordship. But so far as, my lord, inclusion of past conduct is concerned, Honorable Appeals Court has said that past misconduct can be included in a show cause notice or charge sheet, in a present charge sheet or a future charge sheet. There is no bar. In fact, Supreme Court, Honorable Appeals Court says that it has to be included. At the time of penalty, you cannot take the plea of past misconduct while imposing penalty. That I was initially intending to impose penalty of compulsory retirement, but his past misconduct was there. So I'll impose dismissal from service. You cannot do that without incorporating it into the show cause notice or the charge sheet. You have to mention it because the employee is to have a chance to rebut that. So that is the law. So inclusion of past misconduct is concerned, there is no bar. But if your lordships go by the period, that I leave it to your lordship. That I leave it to your lord.
Whether you
It's a Manchi Gora, and that judgment I don't have, but another judgment I have It has been, the Manchegura judgment has been quoted here. There are 19, my lord, kindly have. K. Manchegura.
Yes, there's no quarrel with that proposition. That is why that's no, Mr. You are confusing.
I'm sorry.
You see, when you're issuing the second so-called notice, you see, first, what do you do? First, you inquire as to whether there is a misconduct.
Preliminary inquiry.
You have a no, not a preliminary. You have to inquire through an inquiry officer. You have an inquiry through an inquiry done through an inquiry officer whether what he has done is a misconduct. And he will come up, the inquiry officer will give a report. Yes, it is the case of gross misconduct, it's a case of minor misconduct, whatever.
He said prove or not prove. Whatever.
Or not. Thereupon, you issue a notice, which is the requirement, and say,
And
then
closing
look
the
here, this
inquiry.
is the inquiry report. In addition to that, we now want to impose punishment. And you, on the earlier occasions, these were the things which had happened. And therefore, we want to, thereby you are giving him again a show cause notice to ask that whether, what do you have to say as regards your past misconduct?
No.
Yes.
That is not the correct position.
Kindly see paragraph 19.
Yes. Subject to correction.
Yes, kindly.
Now the question, it has, if the past conduct of an employee is the basis for imposing punishment, the department is obligated to disclose that his past record will also be taken into consideration while inflicting punishment.
So therefore, that is what I'm saying. At the time of imposing the punishment, when do you impose the punishment? First, you have the conduct analyzed or inquired, and then only because the inquiry officer, can you impose just on the basis of an inquiry report a punishment? No. You have to issue him a show cause notice. That look here, this is the inquiry report, and we have found out this is the way. What do you have to say? If you have the past conduct, you have to do it, and these are also the past conduct, so we want to do it. Therefore, before imposing a punishment, because you don't impose a punishment at the time of initiation of an inquiry proceeding, there's the duty of the.
And not we will go through the judgment window, no? But perhaps, I'm not saying, no, I'm not saying for applying this in the,
How much cost will be imposed from you?
no, in the 2025, the penalty order is of 2024, appellate order is of 2025, my lord. Cost will not be imposed or compensation. No, and the trouble we also have, my lord. Also will kindly appreciate.
Find out the roster out here, how many people came out here in Gauhati? At that point of time,
My lord, not our roster, their roster I have annexed, my lord, all
no,
came.
not their roster, here, find out, here in Gauhati much better.
But I'm not blaming him from not coming to the office, my lord,
And
but
if you are not blaming him, then why
No.
you are imposing him?
taking into
punishment.
consideration, not taking into consideration Lordship's view, my lord, with regard to the period. But the thing is that Lordship, at the same time, will also appreciate that the other employees, they also came. My lord. Fine, my lord, Lordship has taken a view.
What
I'll not quarrel with
what
that.
I have thought, if I don't put it up here, I say that, okay, why should we interfere? Normally.
No,
You
Lordship,
see,
Lordship is correct.
No, see, in the normal circumstances, the position is different. Normal circumstances, the sport would not have interfered with this. In subordination, it is
Because of the period, my lord, that Lordship is
for this period, if we are imposing, we don't want the Supreme Court to write a judgment out here to show that not only the disciplinary authority, but the High Court judges were also did not have a heart.
to me. Then where is the meaning of having to proceed? I can appreciate.
Right? They should have been before initiation, they should have stopped it going to all this. Become What has happened to this so-called note? On 29/8/2000, 29/8/2020, page 120. Uh, uh, 2019, what two increments which we need to reflect. That instruction is not there, The outcome of this report is not there. I'll check. Just check. Obviously, now too, you can't proceed. I think there was some logical confusion in 23 show code. There has to be there. It will not stretch to 3 years. To find out. Yes. Because we will need to initiation. The moment if he is, by bringing him, it may lead to an initiation. Yes, ma'am. So for that, I have to give you the liberty. And where is the other person's work? Yes, Lordship will find page 118 and 119 was the order regarding the roster on those days. 119 will fit to the period, page 119. I think it will second last in the group B. So he had absented on 2/6, 4/6, 9/6, 11/6, 15/6, 17, 19, 1, 2, 5, 6, 7, 10, 6, 7, 6, 7, not yes, madam. 6, 7, another 2, 3 days. 166. From 1/6/2020 to excluding the derostered date and also till 16/7/2020. It will be another 2 days, I suppose. Yes. It's 16/7/2020 also will remain absolutely. Record of the DP also I have obtained, the record of the DP also I have obtained.
There are three or four peons. From the page 119, it seems that at that talking, there were three or four peons. They are trying to protect it. As because of me, everything was stopped. That is not right.
Wonderful. The second super. Yes. Where have you mentioned about the earlier? I'm trying to get before a lot. The allegation is of habitual absenteeism, then it has to be there in the charge sheet itself. No, the impugn order contains the punishment. These are the reasons why we have done it, but you have not mentioned it in the, if you go by the judgment of paragraph number 19, the court in so has held that if the past conduct of the employee is the basis for imposing punishment, then the department is obliged to disclose that each past conduct will be taken into consideration while inflicting punishment. And this is the reason why in the second show cause notice we have to mention that that will be in a case wherein in the main show cause or charge sheet there was no mention, but if after the inquiry report the disciplinary authority considers that in past also he has done something, then he'll have to inform this before imposing penalty. Here, my lord, in the present case, we are alleging at the very inception in the charge sheet that you are habitually absent. So that's why in the charge sheet itself we have included, my lord. There is no bar, my lord. There is the bar. There's not a bar. The non-putting of that in the second so will not be conceived because it's already there in the charge sheet, my lord. There was no prejudice cause. It was not a, surprise for him. Since in the show cause itself we have included. So, Did you mention in your second purpose notice what punishment you are thinking? Second purpose, it will be prejudging the issue, my lord. If I propose that I'm ready to opinion, the penalty specified in clause 4 to clause 7, major may be imposed, which are major penalty. Yeah. Major penalty. Tell me this thing, we tell. That is why this does not feature in the affidavit. Why in the roster is no mention of petition for the month of July? One,
And the last one is there.
where is the roster? On top you see only the group B, group A. We are concerned with group B. See on the top, read the on top.
All staff of the office of the undersigned listed in group A shall have to attend the office on all working days with effect from 1/7/2020 to 31/7/2020. The staff listed in group B shall have to attend the office on the dates as per roster duty mentioned below. His name was in group A.
Then the roster was only in respect to this, na?
Two period, two rosters were there. One is 1/7. One is period commencing from 27/5/2020 until further orders. Roster started from 28/5. And another is about 1/6/2020 to 36/2020. Which is the period in question, my lord. 1/6/2020 to 6/7/2020. That is 119 of the.
So in respect to this, in the month of July, he had to appear on every day.
Yes, he was taken from B to A. From 1/6, he was in B. Then on shifting basis, perhaps, my lord, he was taken from B to A. From 1/7.
And what was this High Court's, it is done on the basis of some High Court
Notification was done like somehow at the time of filing the affidavit. I could not get hold of that notice, but it was there. And notification number was also mentioned, which I have incorporated. There was some notification by the Gauhati High Court. Notification number 26, dated 15/5/2020. The order which has been issued is there. I can fight for the roster. Give me a copy. of that notice. There are witnesses who report their colleague, their colleague itself.
When you come to page 46, in the finding,
Page 46.
last part.
The reasons stored in the written statement of the delinquent as well as reply to the show cause notice for not attending the duty seems bogus. It is to be mentioned that during the outbreak of COVID, pandemic COVID-19, the entire Indian government machinery was put in hold. But then also the Indian judiciary had shown exemplary characteristics and imparted justice to the poor and the needy. And the staff of the entire judiciary also has done their part during the roster duty, doing the roster duty so that the justice will not be denied. It is that scenario the reason that the delinquent went through a remote village and could not be able to communicate the reason for such absence in the duty seems not believable at all. The previous conduct of the delinquent also shows that he is a habitual offender and does not have any respect to the institution.
My lord will also
Now,
kindly
tell me
have a
one thing. Now,
page
kindly come to paragraph
818, paragraph 1.
18, my lord.
18. Yes, sir. Paragraph 1. That in reply to para 1, I would like to submit that due to the nationwide lockdown to prevent spread of COVID-19 pandemic, I went to my native village situated at Adabadi, Chetia Handi Gaon, which is situated about 21 kilometers away from Sibsagar. Moreover, all the public vehicle and public transport are not plying due to the ban imposed by the concerned government. And due to the communication inconvenience, I could not attend my office that I don't have any bike or personal vehicle. During the period from 1/6/2020 to 6/7/2020, I was in my native village and I have tried my level best to attend the office, but due to non-flying a public vehicle, I could not succeed to do so.
Now, is there any finding in the inquiry report? Okay.
Page 45. Because he was in Sibsagar.
Where?
Be it mentioned that, Lordship, page 45. Be it mentioned that as per the official record of the office of CBN Sibsagar, which is exhibited as Exhibit 2, the delinquent was absent on so and so, so and so, so and so, which were rostered duty days because of the outbreak of pandemic COVID-19. It is further noted that the delinquent was directed to present on all of his working days in the month of July 2020, but as per Exhibit 3, the delinquent was remained absent on so and so, so and so, so and so. There was no ground shown by the delinquent for those above mentioned absence as the duty during that period. In between 6/7/2020, Shoto's notice was issued against him by the learned CGM Sibsagar, which was replied by him on 15/7/2020. In the reply, the delinquent has mentioned that as there was lockdown and he had to go to his remote village from the rented house in Simlaguri. He was staying in a rented house.
No. He had mentioned that as there was a lockdown,
For
he
the
had to
purpose
go
of-
to his remote village from the rented house in
Simlaguri. In Simlaguri, he was residing for the purpose of his job to do the work. He could not be able to attend the roster duty, and he has mentioned that the same to his colleague. Be it mentioned that none of the inquiry witnesses could depose.
Because we are not concerned to that effect, but where is that thing that you see, there has to be a willful default. Where is the willful default any finding to the truth? That, yes, then also the cars were flying. Where is this one statement in that inquiry? I mean, in fact, those witnesses which have been evident, they have not also known that one car, the vehicles were flying to Sibsagar all this while.
The witnesses in their deposition say that if I just take one deposition, not there were several, I'll just show one deposition what he said. These are all office peon. Page 27, I'm just reading. I am presently serving as office peon at the office of Chief Judicial Magistrate Sibsagar. I know delinquent Sri so and so. The delinquent was serving as office peon at the office of the Chief Judicial Magistrate Sibsagar. Prior to that, he was posted at Nazira Support at so and so. Delinquent remained absent from office without authority during last lockdown. He comes for 2-3 days and thereafter he remained absent without authority for several days. He did not file any application for his leave. When delinquent was posted at Nazira, there was prior departmental inquiry against him as he was absent from duty without authority and he was suspended. At that time, Sri so and so was the chief judicial.
These are not previous things. We are not
His
concerned.
his 2 years, then delinquent remain absent from duty without authority even after resumption of court function after lockdown. Attendance register will speak. Look, I'm not on that. If you
Where is the finding? My question is, where is the single finding? You see,
vehicle was flying.
the vehicles were flying. That is the basic. His specific statement, his specific defense is paragraph 1. That he went to his native village in a year. There's not a single finding to this effect. Now kindly come to page 47. No, kindly come to page 47.
If he goes to his
No,
village,
kindly come to page 47.
Why? I'm only considering not for that. Why compensation? Not for the purpose I'm allowing in this petition is allowed, but for the purpose of compensation. This is how you do. Paragraph 17 has been quoted. Read it.
Page 47, my lord. In the absence, in the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure to devotion to duty or behavior unbecoming of a government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. Now, if the state judgment of the Honorable Supreme Court is considered at the facts and circumstances of the instant proceeding, it is clearly found from the discussions made above that there was no compelling circumstances under which it was not possible for the delinquent to report.
Where is that finding? He was there. He was not there in the native village, or he was there in Shipsagar. He could have attended, he did not. Where is he? What a thing is this?
If I ask myself the same question, if you have some difficulty, I am your employer. If you are having some difficulty, you could have submitted a simple application or a text
You have to
message.
come. How do you come?
No. Why? When you leave,
Do you accept text messages? No, my question is, do you accept text messages? No, if you accept text messages, very well.
No.
No, tell us.
he did not even tell his fellow peons also, my lord.
Ask anybody out there, would they, anybody out there, would they, you see, they are under my control. I write there, no, I'm asking you, I write the ACS. Would they dare to put a text message upon to me and say that, okay, I won't come? No, this is not how the judiciary works, Mr. Das. It looks very fancy from outside, it doesn't work.
Since it was COVID, so that's why I said the text message, but at least some application that look, I am going to my native place. I am Simlaguri. For the purpose of his work, he was in a rented house at Simlaguri. So he could have intimated, given an application that for some
Application is to come, but send it by post. Where's the post
No.
working?
he was at Simlaguri.
No, he was not
working.
in Simlaguri. He said he used to stay in Simlaguri and work in Sipsagar district judiciary, but he went to his native place. That
Exactly.
is what has been mentioned.
While native place, I could have given an application, but some difficulty is there in my place. Those were the things. Those were the things which are expected. The employer expect. Some application that I have difficulty in my native place. I want leave of or some permission to go to my native place. And I'll come back, something like that. If I go, I'm an employee. I want to go to my native place. One intimation will not, nothing will happen. If I give intimation to my employer, I have some difficulty at my native place. I'll move. No leave is required. Casual leave I always have. But at least an intimation, that's how the unauthorized thing comes into play.
If he goes to his native place also by intimating, you may put him behind the bar. Because of the fact that he may be crossing certain borders of the city at that point of time, that was also not permissible.
That was how he went. That is also a factor.
That is also, if he boots it, this is how things were.
That's how he went in that COVID period to his native place. That is also a factor.
You may say that this is a violation of section 100 and, which one there? 118 or 108, there was a provision there. The disaster and management department had created a chaos with this. What is that? 118.
118.
There were orders being passed, anybody violates, we have put behind the bar.
At that time, we have seen that the laborers were coming from UP, Bihar to Assam. On foot.
And what is it? Government of India also has a, yes, those notifications were there, and the department has been issuing several letters requesting for clarification regarding department has issued request for regularization of this project with the department for issue. In view of the fact that the country is going to use the public. The life of the so there, the government has relaxed. Obviously, government of India is very, but I think the state government must have followed suit. State government must have also done something. Only our high court. You just with one thing. We have it on the personal. I know. I know. On 12, 12. Itu mulai ni. When good. Well, put in the kita. Okay, let's go. Top of the list of any. Well, 14. Well, there many matters. On 14. On 14 at the top. 14 to mean. All the matter in the entirety. However, on account of an instruction as to whether, as to what, and what as to what was the, what is the, however, on this court is of opinion that the instruction be placed as to what is the result of the departmental proceeding number 1 of the 2023, which have also been initiated against the petitioner on the ground of alleged absence of duty. On the ground of alleged 1 hour late, late joining of the duties of various dates. It's the matter on 14th of May 2026 at the top of the list for final disposal. The records which have been produced today be again produced on the next day. You just find out you produce you just produce those circulars which have been issued by the Department of by the central government as well as the state disaster management department, whereby interstate travel was
Already
where
page number. Some idea.
where
Page number 91.
oh state assembly is annexure 12, no? Yes. Annexure 12 is of 23, but page 91 is of 18 July. One all inter-district movement of individual and district is barred with a big. Seven. It's not the period of. In this.
Extended. Time to vote. Right.
160.
You can also say about containment zone, quarantine area.
We would have come out there and sneezed. Would have sneezed out there before this. Sneeze before this. Why you are putting all these at a later one? At that point of time, why you are not bringing those notifications which were there? You are all bringing in the month of July. Bring those notifications which were prior to that. These were more necessity.
Take time full of them.
What?
31st, it was.
Mr. Council, understand. We are concerned with the period from 1/6/2020 to 6/7/2020. All these notifications which we are bringing are all after 6/7/2020. This is not going to help you out. Bring those notifications which were prior to that. The Learning Council for the petitioner shall also produce the various notifications issued by the notifications of the orders issued by the disaster management departments of the Central Disaster Management Department as well as the State Disaster Management Department. And then as well as the Gauhati High Court on the administrative side during the period prior to the during the period which was holding the field during the period from 1/6/2020 to 6/7/2000. Because this will be required for you for the compensation of 2 lakhs. Highly. Take the record. Yes. Improve the cost. Oh, yes, the retirement person. Come over.
Instruction to this matter.
Mr. Hassan, when did you come to know that your pension, your book? Huh?
I have stated in paragraph number 6 of page number 7, madam.
Paragraph number?
Paragraph number 6, last paragraph, madam. 6 lines, madam. However, records prove otherwise.
Have you ever been promoted, Mr. Counsel? You've been appointed as a professor and you are retiring as a professor.
Yes, sir.
Huh?
Yes, sir.
When were you appointed?
Yeah, 1990, 1990.
Now in the gradation list, have you not put your signature wherein your date of birth, date of retirement has been mentioned as 34/2026? Have you not submitted any application out there to the effect? Where you are asking for the DPF missing credits for people. April 2005, April 2010, wherein you have put your date of birth on 23/19.
Date of birth 16/4/1960.
Date of birth as 16/4/1966. Is your signature? Then the problem arises because of the Supreme Court judgments, wherein it says that the way it again you should not touch it. Speaking, you knew about all these things, you could have come on.
I submitted my admit card as well as the past certificate. Yeah.
These are admit cards which have been issued recently.
But the duplicate copy of the admit card was. The Lordship may kindly see the page 20 and lecture 2 for the SSLB international certificate memo.
There's no interim order. We will ask them to.
Let them verify my mallet admit card as well as the past certificate.
Will they have it at the time later on? If you are found to be, you have a case, then it is okay, but there is no question of interim orders. I only wanted to see this instruction. Heard Mr. E. Hassan, the legal counsel appearing on behalf of the commission, Mr. S. Sharma, the learned appears on behalf of the when Ms. S. Sharma, the standing counsel appears on behalf of the Gauhati High Court. Mr. S. K. Medi, who with the standing counsel appears on behalf of the accountant general. The petitioner herein had approached this court by filing the present petition on 26/2/2026, alleging and being aggrieved by the non-consideration of the representation submitted by the petitioner on by rejection of the representation submitted by the petitioner on 3/2/2026. It is the specific case of the petitioner that the petitioner's date of birth is on 16/4/1968 and not on 16/4/1966, which have been recorded in the service book. And under such circumstances, the petitioner had submitted the representation, which being rejected, the petitioner had approached this court. This court had issued notice on 9/3/2026 and thereby asked the learned counsels appearing on behalf of, thereby directed the respondents to bring on record their stand by filing the affidavit on or before 21/4/2026. The petition was made returnable on 27/4/2026. On the same date, Ms. S. Sharma appearing on behalf on 27/4/2026 when the petition was listed. Ms. S. Sharma, the learned standing counsel of the Guwahati High Court submit that no copy of the petition was served. Be that as it may, the learned counsel appearing on behalf of the petitioner denied to the said fact. Under, under such circumstances, taking into account that the petitioner herein would retire on 30/4/2026, that is today, this court posted the matter today directing the Standing Counsel of the Guwahati High Court to produce the necessary instructions, with instructions. In that regard, an instruction has been placed before this court, issued by the District and Session Judge Demaji, dated 29/4/2026. The said instruction is kept on record and marked with the letter X. From a perusal of the said instruction, it is clear that the petitioner on various occasions filed necessary, the petitioner had signed in the gradation list as well as also submitted rectification. Submitted a communication, submitted a request for rectification of the GPF missing credits. The rectification of the GPF missing credits on 25/4/2024, wherein the petitioner himself had mentioned his date of birth as 16/4/1966. Under such circumstances, this court prima facie is of the opinion that the petitioner has not been able, the petitioner had knowledge about the knowledge that his date of birth was or have been recorded in the service records at 16/4/1966 as 16/4/1966 and had approached this court at a very late stage. Under such circumstances, this court is not inclined to pass any interim directions. This court further directs the Guwahati High Court, the District and Session Judge Demaji, to bring on record its stand by filing the affidavit. The said affidavit be filed on or before 4th of June 2026. List the matter on 18th of June 2026. Liberty given to the petitioner to file reply. Full stop. It is further observed that though this court had not passed any interim direction, full stop, the superannuation of the petitioner on the basis of the date of birth as 1/6/2001 as 16/4/1966 shall be subject to the outcome of the petition.
Verify my input card as well as the person taking it.
Have you made the SEBA party? Then whom should I ask? Tell me. Give me a good idea. Mr. Hassan, you have been all along on the other side now for a long time. Accountant General.
Judicial department is the party. They can verify my.
Judicial Department. Who appears for the Judicial Department? They cannot verify. You have to make the SEBA part. In the meantime, you make a SEBA. We'll ask them. File an IA for that. File an IA. So if there is more role, the AG does not give anything, no? He will cut. What is this?
The petitioner also
Lordship, here they have challenged the outsourcing of.
Affidavit filed.
No, Lordship, here we need some time, the 2 weeks time to file a affidavit, Lordship.
This is the second round of litigation.
No.
Earlier round of litigation also there was no
Lordship,
final.
there was a.
This is not the second round of the litigation. This is the second with petition
Lordship,
file.
Yes.
This is different. Mr. So-and-so, A. Tolia, the learned counsel appearing on behalf of the finance department submits that 2 weeks' time may be granted to the petitioner of the respondent finance department to file an affidavit in opposition to list this matter again on 18th of June 2026. In the meantime, the finance department shall file the affidavit in opposition on or before 11th of June 2026. The respondent, the Guwahati High Court is also directed to bring on record the stand by filing the affidavit on or before 11th of June 2026.
Oh, yes, what is that in this matter, we are going to file this advertisement by excluding that clause.
Have you got any notice?
Madam,
Have you been informed by
they inform me
some letter?
by letter and their note sheet, madam.
You got it? So then we close it.
At page 3, madam.
Where is the approval?
Madam, the processing.
Huh?
Kindly,
You cannot say that the honorable judges have not, this is a thing which have been only placed.
and
Please find
they are
out if
go-
the
they are
approval
going to-
dated so and so granted by the, has the approval granted?
the process is on, madam. That's what
What process?
I was informed, madam.
We have the above raised two proposals as well. This is a proposal.
Yes, madam.
Candidate who have already submitted online and may payment of fee in so and so on the year may perhaps be requested the. Okay. Perhaps be allowed to complete the process and for the other proposals. No, no, no. Let us produce that order. Mr. G. was the limit. Senior counsel as well as the standing counsel of the Guwahati High Court submitted there is the process to there is a proposal being submitted before the respective committee for the purpose of for the purpose of issuance of a fresh advertisement after deletion of clause 2C of the advertisement dated 18. Advertisement dated. What is that date? 18/3/2026. Insofar as the engagement of temporary engagement of 3 vacant posts of law clerk at the principal seat. It is the opinion of this court that the said aspect be brought on it is the opinion of this court that the registry may place before this court any such proposal having been accepted and approved, thereby withdrawing the advertisement dated 18/3/2026 before this court on the next date. List the matter again on 11th of June. Right. Interim order passed earlier, so it continue. Till the disposal of the petition.
DP of last.
All right. Read this.
My lord, this case, my lord, the petitioner was running a my lord, Joel, the my lord respondents, Assam Tourism Development Corporation, my lord. My lord, and land, government land was acquired. And where my lord, petitioner, my lord, constructed Assam type house and some trees, my lord. For that Assam type house and trees, my lord, the compensation was, my lord, assessed and it was paid to the petition. Now, the agreement was entered, trace agreement was entered. This one, so now respondent minor is claiming that this completion and also works. So they made in that I way of claiming they have seized my articles, they have cancelled the agreement, and they have seized my articles without law. This is the case.
Your agreement is cancelled.
Cancelled.
You have not challenged the cancellation.
Yes, I have said.
Yeah, you have challenged.
And this regulatory
You
seizure.
have got some interim directions.
Yes, Lord.
You provided in an undertaking. What is the interim order?
There is no coercive action, further coercive action.
And now you are not being disturbed.
But the thing is that my all these articles, my lord, it is a captivity, my lord, had before, and it was seized. And without being a particular, I don't know where is the power they got, my lord, to seize my article. Now,
Who has done it?
but
Who has done it?
my lord, this response. Assam
One of
Tourism
them,
Development
many
Corporation.
responses are
Assam Tourism Development Corporation. Now, my lord, by the last order, this honorable court was pleased to ask them that whether this land, they were saying that this land belonged to us. So this acquisition, this compensation amount was given for the land. Now this court asked them to produce some documents as to whether this land is land or that land. They filed their affidavit now. In the affidavit now it is clear. Here's also the additional affidavit they filed on 21/4.
But then it say,
Yes, page 110 euros. This is the deputy commissioner of my not as letter to them. Page 110. Have I got it, ma'am? Yes, my lord, that's the second land. Being government, the second paragraph, being government land, no land bill was considered during assessment of compensation. Only the bill of structure, Zirat was considered. A copy of fees estimate is enclosed for reference. On assessed land value, 100% solution and 12% issue cost is also paid as compensation. Lordship, that would next page, your lordship. They have given the assessment. At 71, that number, your lordship, like you see that. Fourth column. That opposite property, land is government. And his land value is 0. Zirat is 11,050. Then below of estimate till the 40, and now the assessment because of this.
got the money.
Yes, sir. I have got the money, and they have not raised any objection regarding
Yeah.
Now they are claiming they have filed the FIR against me, stating that I have defrauded them in collusion with Latmondal and Gaupura. I have defrauded. They have lost the FIR. This case is going on. Criminal cases.
This acquisition is made under what provision? This acquisition has been made under what provision?
Well, land acquisition.
There are many land acquisition. Which one?
Well, this. So the person has been provided. It is a new act. Like,
I think it must have been done under the Acquisition and Acquisition Act. Where the government did not follow the 2013, but only the compensation.
compensation amount is
So this must have been done under that provision. Then they are agreed why they are not filing an application but fighting with you before the deputy commissioner for seeking a reference.
No, my lord. They have not filed any.
I think we should impose cost of water.
May it please your lordship. Lordship, I'm appearing for 3, 4, 5, 6, your lordship.
Why
Lordship,
are you taking the law into your own hands?
lordship, if I may
You
bring
cannot
the
take the law into your own hands. There is a particular procedure. If you have any problems that regard the compensation being paid to the petitioner out there, then it is not a case of fraud. It is a case that you have to make, approach the competent, the collector for seeking a reference. You don't seek
lordship,
a reference, then you are fighting with the petitioner. This is beyond the purview.
lordship,
This
if
is
I
a
may
case
submit,
of, I still remember the judgment of the Supreme Court, it is that case wherein it says that unequal bargaining power, LIC versus Consumer Research Association.
lordship,
1995,
if I may,
file
lordship, with all humility, if I may submit,
that purview.
lordship, with all humility, if I may submit, lordship,
No, I
lordship,
think,
I want to draw the
what do you want?
attention.
We allow you all, everything of your reputation.
No,
What do you
lordship,
want?
lordship, if I may,
We
if
can't hear anybody from them.
lordship, lordship, if I may submit, your lordship, lordship, I want,
For compensation also, Mr. Counsel.
lordship, if I may be allowed to submit, your lordship,
On selling the contract.
lord,
The cancellation of the contract, we have to go for the.
Yes, they may sue that item.
Then what do you
lordship,
want
there
here?
is no privity of contract between him and me.
Released to be released, should be released. And for the compensation, my lord, I can go to civil.
Yes, see, material.
Yes, your lordship.
Lordship,
And what do they say?
everything belongs
Do
to
they
us.
say that- Do they admit that they have seized?
Yes, your lordship.
Where?
My lord, your lordship, I have a annex here.
Where? Have you filed an FIR?
Lordship, I have filed an FIR.
They have filed a file.
No, you have
Lordship,
not
the
filed an FIR.
magistrate was
have not
present when the,
Somebody is taking something without authority.
Yes,
Without an
my lord,
authority, it's a case of stealing.
Yes,
Yep.
he was residing and.
Earlier, at that point of time, it would be 79.
Yes, your lord.
The case of 379.
Exactly.
Yes,
The case of
file a 379
Yes,
again.
Caesar Leaf, your
Managing
lordship, I paid
director of-
46, your lordship. At 46, please, Caesar.
File an 379 against the managing director of ATBCL. And
General.
that I think is better. Who has filed the affidavit? File it against him also. Yes, file it against this person. Passport Rupi
no, Lordship, may I just submit, your Lordship? No, Lordship, this entire case has been present very wrongly in front of this honorable court, your Lordship.
You go ahead and do that.
Lordship, may I just submit?
46, your lordship, yes, Caesar.
Remaining question, you have to go before the Supreme Court.
Lordship, if I may submit before this honorable
Can't
court.
hear anything from there.
Lordship, I will be there in court on Monday. Lordship, I'll be
hear
there in court on Monday. Lordship, if may, Lordship may
I
just
can't
post
hear
the
you.
matter for Monday or Tuesday, your Lordship.
I can't
Any day
hear
next
anything.
week. Lordship, any day next week, your Lordship.
Why?
Lordship, there are lot.
This is a case of theft. Theft is non-bailable. So
Lordship,
non-bailable,
the materials belongs to us. Lordship, all the materials.
File a bail application for your managing director.
Lordship, all the materials belong to us. He has some. Lordship, Lordship, during the
You have allowed
confiscation.
them to use it. The
Lordship,
moment you have allowed them there without their permission, how can you take it?
Lordship, the magistrate
It's a
was
case of
present. Lordship, the magistrate. Lordship, if your lordship can just give me 1 minute, I want to show your lordship
Can't hear you.
that how the land belonging to the petitioner to the
The
respondents.
system is not proper.
Lordship,
You see, our high court is, the courtroom is not acoustic enough to hear what you are saying.
Lordship, mate, please, Lordship, just
Can't hear you.
post the matter any day on next date.
You have filed the affidavit. Reply.
I have not requested that post is, my lord, already in my paper. That whether it is a government man or ATBCL.
And that is also, there's no problem with it. No, you want to file any.
They have repeatedly
No,
same
Mr.
things.
Sharma, my question is to file a reply. No. On the materials on record, 15. that an affidavit in opposition has been, as well as an additional affidavit has been filed by the respondent number 3, 4, 5, and 6. Mr. M. Sharma, appearing on behalf of the petitioner, submits that she would not like to file any, he would not like to file any reply. The petitioner would not like to file a reply, but submits that the matter be taken up for an early disposal. This matter on 4th of June 2026, on which date an attempt shall be made to dispose of the.
Much obliged, Your Lordship, much obliged.
Yes, Mr. Roy, you are sitting for some matter. So you may leave them. Take your day. Yes, what has happened? Have you been otherwise terminated?
No, my lord, he has approached the honorable court with regard to that termination order. And my lordship has directed, we cannot submit the enquiry report, I guess. So for that, my lordship has directed to submit the enquiry report, and that is going on. My lordship, this is different.
What? Now, what has happened to the appeal in the area?
That proceeding culminated into a penalty.
An appeal has been filed.
Yes,
What has happened to the appeal?
Lord, the proceeding wherein appeal has been filed, that culminated into a penalty, and that was challenged before your lordship. Lordship has
Is another appeal pending.
Yes, my lordship.
Because of this order, see what has happened. What is my interim order passed? My interim order was passed. But look here, kindly don't take this as a procedure in while deciding that appeal. So what has happened to that appeal, which is appeal number?
The appeal of that status of that appeal is not known. Status of that appeal is not known. And with regard to the enquiry report, since it has been remanded with regard to that observation, I think a fresh proposal has been issued to my lordship with regard to that by the honorable. This is just a fresh proposal has been issued with regard to that appeal. My lordship, this person with regard to the interim order, there was an appeal pending. In between the proceedings of this matter, I think the month of February, my lordship, I forgot the date, it was before your lordship. That with regard to that appeal, he was not provided with the enquiry report. My lordship has gone for the records of that case, and my lordship found that there was some error in the proceeding. So my lordship has directed provide the enquiry report and their need to. And as such, as per my
So there was a second super notice without an
yes, my
inquiry.
yes, my lord. As per my
So therefore I interfered there.
yes, my lord.
So that matter has gone now for that.
Yes.
So it has now gone to the stage of penalty.
Maybe
Obviously.
and
enquiry report was
So
not
now
filed.
the inquiry report will be given means it will go to the stage of penalty.
penalty. My
That
lord.
appeal which was involved here, Major, in the interim order, perhaps that appeal has got merged with the subsequent order.
So therefore, that was a challenge out there where in spite of the appeal being pending, I passed that order.
Yes,
Fine.
Somebody else appealed, huh?
some other council appeal.
The council here,
So I therefore send it out there that give us
Yes, fine.
opportunity.
Aside
So therefore, my interim order which is there is not effective.
no, my lord.
Because
nothing.
Yes, my
So then there is no urgency. Whenever I pass an interim order, it is already ahead.
my lordship, my lordship, my already to certain extent in this matter.
I remember, don't need to say, it was regarding that execution petition, no?
Yes.
Which was not placed. That particular application was not placed before the year for which he passed an order. The judge passed an order without notice to this fact that there was some order passed by this next.
My
No, without the notice that there was an application also signed by somebody else which is pending.
yes, my lordship, and he was the person who was also granted relief in that application also. He was the same person who has done order for the execution, and he was the same person who has also granted relief in the other need also.
you say that you should have informed.
Yes. And my case,
Nice way to put the blame. Like tomorrow, if I pass an order wrongly, I'll put the blame upon him. Something like that. It's would it nice, look nice for a judicial officer to do so? My only question is that. If I pass a wrong order, the three persons put the blame. That's for that. That's the answer. Yes, they apply. Yes, there might be many mistakes. Yes, but then you get a lot of orders where the account number has been wrong mentioned. That way, in one of the cases of decreasing an account number which should have been 79, the last unit should have been 79. They put it 9%. So the account number is wrong. Yes, mistake is there. You work for a judge, you don't look into those and keep it there. But I can't put the blame on him. He had to do person for accident. You did the same to
That's a slightly different. It is their version.
Okay. The interim order has no relevance. Okay, let us then have it after summer vacations. Almost stay also. There was the only penalty of that amount. Huh?
Yes.
actually, with regard to penalty also, my lordship just asked one different penalty for one major and minor. Upon
That I can. I have CAB, so I can't do all these things. I don't normally have a CAB, but I'm finish it off next week, day, and tomorrow and day after, and then I'll. But this is their entire case. Putting a blame upon them. But what was the penalty?
In this case, my lordship, one
Minor or major?
major and one minor.
Your submission is also that there cannot be two types of penalty.
On one side, one side pays for the compounding two penalties, one major and one minor. Pays one major.
Very interesting. We'll hear you on 2nd of June, 2 p.m.
My lordship.
With the matter of second, you may have difficulty nowadays have difficult 2nd of June, 2nd of day. Would you like to on the phone? Busy council for that.
No, lordships normally keeps him Thursday, my lord. See?
That's similar to it also now. My lordship.
On the blessings of God.
Thursday can be taken up to 4th of June. That is our normal day of High Court day, my lord.
The matter, the matter having been almost heard, and the matter have been really heard. This the matter again on 4th of June 2026 at 2 p.m. for final disposal. Liberty given to both the parties to mention the matter in the circumstance. Liberty given to mention matters. Showing it as part. So it's already part.
Already signed the part. Already part.
Yes.
Very moderate in
Item.
remember 1920.
What is that matter?
But if the matter pertains to a particular bond in the TSA, pertains to a bond in the Sonari TSA.
Oh, that one.
Yes.
I remember, yes. As to whether the bond can be a part of the government land or so and so. They say that it is a government land wherein you say that it's a part of your.
We say it is a part of our estate. And the government says that it's a public land. Classification of the land was changed.
So your basic thing is that you have to acquire the land, you can't do it like that. And the second petition is pertaining to a road being constructed.
Yes, they want to construct a road.
Road, and therefore you say that this road, if you want to do it, you have to acquire the
Yes.
land. That's your case.
Can it be on Tuesday
Tuesday,
or any other day convenient to your road?
there's no date convenient for me. I'm always at the disposal of the lawyers. Yeah, because they become well with my. I think the 14th matter on that, that will be in 1905 2026. For final disposal. The in-game order passed the year shall come.